effects, and then later on we'll be discussing what conditions would be appropriate in the event that ministers were minded to grant consent for the scheme. Most of us, but not all of us, were here earlier on, so I think it probably helps to run round and say who we all are, run around the table before I explain exactly what we'll be doing and we get started. My name's David Bouillier, I'm the reporter. I'll be writing a report at the conclusion of the inquiry to ministers with my recommendation as to whether consent should be granted. If I can turn to the applicant side, maybe if you could all just, anyone who's intending to speak or contribute, if you could just introduce yourselves. Thank you.
Yes, good morning. My name is David Bell. I'm planning consultant advising the applicant on planning and energy policy matters.
Marcus Trinick, advocate. I'll be also talking during the policy session.
Ian Kelly, consultant with Graham Sibbald, representing Save Wild Moray. There's a couple of preliminary points I'd like to make, sir, in due course.
Jörg Bonzio, I'm representing myself, my wife Fiona, and our businesses Sporting Scotland Limited and Coglas Holiday Cottage.
Sir, I'm John Campbell. I'm a Queen's Counsel at the Scottish Bar, and as you know, I'm with Mr. and Mrs. Bonzio.
Yvonne Mandel from Glenarder and Glenarder Holiday Cottage.
Good morning, I'm Gary Templeton, Strategic Planning and Development Manager, excuse me, with Moray Council.
The only one from the council speaking, as far as you know.
I'm not sure. Mr McPherson may wish to contribute.
Yes, Neil McPherson, Principal Planning Officer. I may contribute to the discussion as well.
Ms. Scott, you might want to dive in if you feel the need, but okay, fine. Okay, before I sort of run around again, just to see points that anyone might wish to raise, including Mr. Kelly. As I said, the idea of today is quite an informal discussion. I need to get to the bottom of where the parties stand on the matters of planning policy, socio-economic effects, and then finally conditions. The idea is it is reasonably structured in line with the agenda that I circulated back in August, I think it was. It may be that there are matters that I have omitted from that, in which case, if I think they're relevant, I'm quite happy for things to be added, as long as it's not something completely out of the blue, which other parties haven't had the chance to think about. We'll rattle through it and see how we get on. It's not, as I say, it's intended to be informal, but it's not intended to be a complete free-for-all. I generally am quite relaxed about if parties genuinely want to ask a question of another party to understand better where the differences lie. That's not generally a problem. I don't have any major issues with that, but it's not and I'm sure it wouldn't be from the parties who are involved today, but it's not a chance for there to be a big argument about matters or a lengthy cross-examination of each other. We need to try and get through quite a lot of material, so I'll try and keep us rolling on. I really need to get to the bottom of where everyone is on the issues, and I want everyone to go away feeling that they've had the chance to tell me all they wanted to tell me on these matters, which means we do need to make some reasonable progress through the agenda. I will keep quiet now. I think I'll just run around the table if anyone wants to raise anything before we kick off.
Thanks, sir. The version 11 of the conditions has been circulated to all parties this morning, and there's a copy for you that represents the up-to-date position. That's the first point, and my only other point relates to the Natural England document that was submitted. I've had a chance to skim through it. I don't think we need written representations. I think I can deal with it in submissions without giving too much evidence. And I'd rather do it that way than have yet another process interpolated.
Does anyone have a different view? No, that's fine. You happy with that, Mr. Campbell? I think I haven't read it yet, so I think it would only be if something struck me as very unusual in there that I'd want to ask anyone to make any further a formal round of written submissions. But if there's anything anyone wants to say in, that seems the logical place to do it. Mr. Kelly.
Thank you, sir. Just a couple of points before we go into the agenda. On the matters of policy, the underpinning position of Save Wild Moray is one of supporting the Council's position, and therefore I hope that, or I will certainly try to avoid any contributions that are simply repeating the Council's position. On socio-economics, I wasn't clear from the agenda whether you really wanted to focus on the specifics of the effects on Sporting Scotland Limited and Miss Mandel, but we'll just wait and see. More important point, on conditions, whilst we still have some concerns about the MOD and the Habitat Management Plan, I have followed the emerging versions of the conditions. Save Wild Moray has no concerns with the detailed wording of the conditions. We're content to leave that to the Council, yourself and the applicants, and therefore Save Wild Moray will not take part in the discussion on the conditions, as they are perfectly happy with the emerging versions. Finally, sir, I don't think the subject of site visits has yet been mentioned, but in case it comes up at the end after I have left, the position of Save Wild Moray is that they are perfectly content for you to do all the remaining site visits on an unaccompanied basis, rather than have an entourage going round the viewpoints. Thank you, sir.
Thank you. Just on that, the point about socio-economic effects, and I appreciate my agenda, such as it is not very specific. My intention was to consider both the broad picture, which you'll be very familiar, about the evidence that there is any harm, but also I'm particularly interested in the localised effects, not necessarily just the immediate neighbours, but perhaps things of which your client is interested. So you're very welcome, obviously, to take part in that. Mr. Bonzo and or Mr. Campbell, I don't know if you each want to say something or anything.
No, we have no preliminary points, and I'm grateful for that elucidation of the agenda, which will come to in due course. You do, of course, have a hearing statement from my client in this regard.
Council?
Just again for clarity, the Council is obviously presenting just now in relation to policy, but just for note, we're not taking part in the socio-economic part of the discussion, so we move ourselves to that portion.
You'll recall yesterday a question in cross-examination about a quotation in Mr. and Mrs. Bonzo's inquiry statement. We are embarrassed to report that we cannot find it, and are completely at a loss as to where it came from. Certainly we didn't make it up, but it must have come from somewhere, but we haven't found it. So the question was correctly aimed, and we acknowledge that it's not at least an attributed quotation at the moment. Of course, if the position changes before the end of the inquiry, I'll advise you, but we've had a pretty thorough look, and so this is, I suggest, not terminal to our case, but it's nevertheless correct that it be identified properly. I'm grateful.
As am I. Thank you, Mr. Campbell. Okay, well, turning to the policy session, the general approach I want to take is to look at the list of documents that I set out in the agenda. What I'm trying to get to really is to what extent parties think each document is relevant, and I may also have some specific questions on elements within the documents that I either don't understand, or if I think they are pointing in one particular direction, and I'd like some advice from parties as to whether they agree with that or not. In some cases, it may be that I have no specific questions, but it may be that those who referred the document to me may actually want to tell me something as to why they think it's particularly important or not. One thing I did forget to include, specifically within the list of documents, was the sort of international perspective. And I'm conscious Mr. Bell's statement, he reminds us of various international commitments, some of which may not endure very long, but some of which are not connected with the EU. I omitted those in error, not because I was ruling out their relevance, but I thought maybe before we get onto the agenda items directly, if Mr. Bell wants to, or any on that side of the table wants to say anything about those, or indeed anyone else, as I understand it, there are various agreements and there's international panels on climate change and things, and over and above the various targets that the EU has set and which have been discussed over many years as to how our progress is against those. And the question is, of course, whether those will continue to matter in terms of the actual penalties for not complying with targets, if that's what happens. But can I just ask Mr. Bell, I guess, do you want to raise something specifically about the international dimension?
Yes, I was going to cover that briefly because I think the key point to focus on in that will be that last year we had the IPCC report that stressed the importance of staying below 1.5 degrees in terms of global heating. And in response to that, the UK, the Scottish and the Welsh governments, in light of what the Paris Agreement struck, asked the Committee on Climate Change to examine all that evidence internationally and to come up with independent recommendations. And the CCC reported this year, we've set out their advice in the evidence, and the government has acted on that. So I think from the international perspective, those are the key points. It's the IPCC report, which is referred to in evidence, Paris Agreement, and then what advice the government's taken from the CCC. The third element would be the European dimension, but my understanding is that the existing commitments have transposed over into UK law until they're then changed, but I will defer to the legal expertise in the room if there's any other views on that. I think the key point for me would be the CCC's advice and how the Scottish Government has acted on that, and we'll look at that in some of the other documentation.
Does anyone have a differing view as to the international perspective?
That's a fair enough account of what the legislation says. You have to look in the legislation, of course, for the safeguards about deployment of renewable energy sources, and they're all there. So a balanced view of international instruments, just as with national policy, and I'm sure Mr. Bell would agree with it, is that they all contain sensible caveats about the appropriateness of the location of different types of renewable energy generation. And of course, that easily transposes into a local argument, but I'm not trying to do that just now.
Okay, thank you. Moving on, I suppose there are two, the next, or the first, in fact, bullet point, and the second one on the agenda, which are the onshore wind policy statement and Scottish energy strategy, both December, I think it was, 2017. I'll take them separately, although I think they were published pretty much simultaneously. I know... My point on my notes. I know Mr. Kelly and possibly Mr. Campbell, certainly Mr. Kelly has expressed some views as to, correct me if I'm misquoting, but the legitimacy of the Scottish Government in getting involved in the creation of energy policy, which is, I think you say, not a devolved matter. However, we have these documents. They are quite a bit more recent expression of policy than we find in MPF3 and SPP, some 3 years or so younger. And as you'll be aware, they're often matters that are put before inquiries as being relevant to land use decisions in relation to energy proposals. I think I had quite a number of points, looking first at the onshore wind document, which is, I think is CD 6.1. I had a few queries or things that struck me in that I wanted to talk about. But first, if I could just ask, I suppose, the applicant side as to, just to address that question as to, is it really, notwithstanding the fact these documents exist, or this document, the onshore wind policy statement, is it really a matter for Scottish Government, given that energy is not a devolved matter, energy policy? Can I ask that first?
Yes, I think I cover this in my hearing statement at section 5.3, and it's right that energy is a reserved matter, but all the UK level route maps for energy make it explicitly clear that the devolved administrations play an important role in the attainment of the overall UK and international positions for renewable electricity. And there has been practice of successive governments following that line, and the Scottish Government and indeed the Welsh Government have now produced policy statements on energy. The Scottish Government has for a number of years, and there's no evidence that they have been trammelled in that activity by Westminster Government at all. In fact, it's the opposite. They've been encouraged, the devolved administrations have been encouraged because of the contribution they can make to the overall UK position, and especially through the planning system, which is not devolved. Which is devolved. Yep, yep. Indeed. There are some points I would certainly make on the onshore wind policy statement itself, but perhaps you want to come on to that to show them.
Yeah, please. I had a number of bullet points. I've probably missed a few that you think are important in it. Before I do that, though, was I horrendously misunderstanding you or misquoting Mr. Kelly? Do you agree with that?
The position is part one of semantics. It's the title of the document, policy. The Scottish Government is certainly entitled to set out its strategy and its aspirations, but it certainly cannot create a new energy policy as such. As Mr. Bell indicated, perhaps a key consideration is how these documents translate through into planning and consenting decision-making systems.
So one point on that, I think in the Scottish Energy Strategy, which we will come on to, one of the priorities identified in the document is the implementation of the onshore wind policy statement. So not only is the policy there, the clear strategy of government is its implementation, the application of policy in decision making.
And in terms of the track record since 2017 of planning and consenting decisions, would you say that it appears that this is being taken in, or these two documents are being taken into account in guiding the decision-making process?
Yes, I think in the large body of appeal and second, third, sixth decisions that there are some reference the document specifically, others don't. My view, and the applicant's view, is that it is a highly material document and there's very relevant considerations within it to take into account. One example I've referred to in my evidence is the reporter, Mr. Tim Bryan's view in the Penclow decision, that it's clear from these documents that the government view on onshore wind in particular and its deployment is being intensified, that policy support. So I think there is recognition of the government's ambitions and drive in this particular sector in response to the policy document that's at large for decision makers to deal with.
Mr. Kelly, is your point that in comparison with something which is clearly a planning policy document like SPP or MPF3, that these documents are of less weight, less legitimacy, or again, am I misunderstanding, misquoting you?
They are a material consideration. I think the conclusion I reached in the hearing statement is that of their own accord, they don't change the need for a balanced approach, of the planning balance of looking at the disbenefits and benefits. As I tried to perhaps blithely sum up in my statement, the documents on their own do not make an unacceptable development somehow acceptable. And I think that sums it up. Thank you.
Mr. Kilman.
Crudely, the Scotland Act of 1998 reserves energy to Westminster, and that's all it tells you. It just has the word energy in the schedule, which deals with what is reserved and what is devolved. What has happened in Scotland is that has been, if I may say so, largely ignored by the increasingly ambitious Scottish Government. Now, I don't say that's wrong, because it's quite a sophisticated constitutional law argument, and not for here to discuss what happens if something that is plainly not devolved actually by osmosis becomes devolved. But where we are, Mr. Bell's quite right. The Scottish Government's ambition has been translated into a range of policy documents over the last decade, from the route map through to where we are now, the 2017 documents, and no doubt there are others in the pipeline, no pun intended. And I'm sure you'll come to the contents of the onshore document, but it won't do for an objector to simply say energy is not a devolved matter, so none of this counts. Because I think we must recognise that is not that statement does not reflect reality. So whether by naked ambition or political will or a combination of the two, we are now in a legal jurisdiction where energy de facto and controlled and legislated and was created by the Scottish Government, the elected Scottish Government. That, of course, the matter for you. I agree with Mr. Kelly. I'm making big concessions. It's specific, and my interest is, as you know, particularly local in this case. I think Mr. Kelly's quite right when he says they're a material consideration, and it would be wrong of you not to notice them in that regard.
So I think it's a very wise way of putting it, if I may say so. I think that the lines between what is energy policy and what is the implementation of energy policy are pretty blurred at the best of times. I wouldn't want to get in that too much. I've got nothing to add of any use at all. So I think I agree with all Mr. Campbell has said.
Just on the question, the general question before we go into any details, do the Council have anything extra to add to that?
No, it's the same as the Council Chamber asked. No, but I think as we work down the agenda, we're going to find quite a common theme here that I don't think anybody around the table is going to argue against the climate change emergency and the challenges that we face nationally. But as Mr. Campbell said at the outset, within all these documents, there is that balancing statement, the caveats about protecting the environment, and I'm sure we'll get into that in detail shortly, but I think that's going to be a very common theme. And even, I think it was worth noting in the document again, which we'll get on to, Protecting Scotland's Future Programme for Scotland, there's a very key statement in there which says that the challenge for the move towards decarbonisation of Scotland will be set out, or how we will achieve that will be set out in National Planning Framework 4. So really I think that while all these documents set very important context and background to the challenges ahead, I think greater weight should be given to the National Planning Framework and SPP.
Thank you, that's helpful. So looking at the OWPS, try and find CD 6.1. I believe. Yes, 6.1. A list of points, some of which, given what has been said, I may not need to necessarily dwell upon. Some of them, such as towards the start, talk about the vital role of renewable energy. Paragraph 2, expect onshore wind to remain at the heart of clean, reliable, no-carbon energy future, blah, blah, blah. I don't think anyone is actually querying that is Scottish Government's policy that onshore wind is and will remain an important contributor.
Question whether it works or not, that's not questioning the policy, but there's no evidence about that in this inquiry, so I think it's a discussion for another day.
Indeed, I did want to, as I think you, Mr. Campbell, had raised it, and I'll come to it later, the question about how one can make use of the electricity that's generated in this way and what constraints there might be to that physically or in other forms. So I will certainly come on to that point. One thing I did jump out at me. It also, I think, crops up in other documents that we'll look at later on. Paragraph 3, and I think, again, this was a point possibly raised by Mr. Campbell, in that paragraph 3 of 6.1, page 6 of the OWPS. Yeah, it says. It'd say onshore wind generation will remain crucial in terms of goals for decarbonised energy system, and then it goes on to say helping to meet the greater demand from our heat and transport sectors. And later on, I think it may well be in the report of the Committee on Climate Change, I may be wrong there, but there appears to be thinking developing as to if we are to see an improvements to the heat and the transport sectors, which appear to have been lagging behind the electricity generation sector, then there will need to be a shift towards things like electric vehicles, etc., and electricity to be used for heating. And I just wondered to what extent, although those are not energy generating or electricity generating matters, they do in fact offer some support, given the apparent need for those sectors to become electrified, if that's the right term. And also, I think as we come to later, there was a specific point raised by the Climate Change Committee as to the ability of intermittent energy sources such as wind, which tends to do better in the winter, and how that can actually correlate quite well with an increased electrification of the heat generating sector. So it's what I'm trying to explore is to what extent those two other elements of the aim to decarbonise the economy which have traditionally been seen as separate from the electricity generating aspirations with which we're usually concerned, to what extent the electrification of those sectors actually aids support for a proposal such as this? That was a very long question, but I'll start with Mr. Bell.
Yes, no, I understand what you're getting at there. I think it's clear in the Scottish Government documents and the UK ones that the country has done well in terms of the electricity sector and decarbonising it. Where there's been very poor performance has been with buildings in terms of heating and cooling and transport. And those are the sectors of the economy where the CCC has rightly said there needs to be attention paid, because it's about 40% of emissions for climate emissions come from buildings and real estate. And there will be a drive to get rid of gas boilers and to move off the gas grid and to go to massive electrification from low-carbon sources in urban areas. So the government at the UK level and at the Scottish level is driving what's called local area energy planning and smart systems. And in fact, I've been advising the Energy Catapult in Birmingham on that for the UK. And it's how do we deploy this massive change? And partly it's coming down to a change in the energy system that will involve storage of energy, the adaptation of local systems to accommodate that different generation type, district heating from low carbon and renewable sources. And the grid plays a role in that, as well as decentralised sources. But what is clear is that the CCC has said in its report that there needs to be this massive increase in renewable low-carbon generation, and they specifically address the intermittency point to say that that can be managed.
Maybe come to that.
So
it's my fault, I was jumping ahead, but yeah, we'll maybe come to that in more detail later as we get to there.
So there is a role for renewable energy generation to deal with those other sectors that are lagging behind and that still will lead to increased demand and are at the moment resulting in large-scale emissions.
Does anyone disagree that the apparent need to focus more attention on those other two elements that are causing carbon emissions in the economy, so transport and heating, does anyone disagree with what Mr. Bell said, that in fact efforts to improve those may actually support, assuming that they do actually contribute, that they may actually support additional renewable energy capacity, renewable electricity capacity?
That's the very question. That's the leap in logic that Mr. Bell makes, which is unqualified and, in my submission, mistaken. What he has been talking about with his massive experience is the adaptation of local systems, district heating schemes, and then in the same breath says, and that will lead to a massive increase in low carbon generation. Well, it may do locally, but what the CCC is about when it's talking about transport and heat and building heating issues is about adapting systems, not necessarily increasing generation. So, with respect, it's a jump in logic, as I see it, at least from the answer that was given to your question, which is not necessarily justified.
Can I also say that we seem to be drifting, bearing in mind we're talking about a 7, potentially 6 turbine development here, we seem to be drifting into very, very wide-ranging future policy issues. We also, if we're going down that route, need to take account of the offshore capacity built and consented and feed that into the assessment as well. There is no doubt that there will be strategic changes in the future in the approach to electricity generation, distribution and use. But I think we are a long way away from those strategic changes feeding through into the planning decision-making system. It's not to ignore them. They are going to happen, but there's a decision to be made just now, and I would suggest that that is a local decision.
Could I also just add a comment, if that's okay? The two sectors that are being mentioned as lagging behind in terms of transportation and buildings, they are identified quite clearly in the programme for Scotland as well, with quite radical reforms and improvements to bring them up to speed with the other issues.
Okay, thank you. So, turning to perhaps matters that are more directly or obviously linked to what we've been discussing in regard to this proposal, I note in the Minister's introduction, foreword, whatever it's called, page 3, I think it is, possibly. No, I've lost my reference now. Thank you. All right, yeah, sorry, I found the point I was trying to make. The third paragraph. Get it right. Sorry, I've lost the ability to read. So the important role means we must support development in the right places, which is what I think we've been well aware of. Increasingly, the extension and replacement of existing sites where acceptable with new and larger turbines. And we talked earlier in the week about the technological move to larger machines, which I think we all agree seems to be the trend. And then later on, I think it's paragraph 23.
Sorry to interrupt you, sir, but just for the members of the public here, that sentence you read out continues where acceptable with new and larger turbines based on an appropriate case-by-case assessment of the effects and impacts.
Absolutely, Mr. Kelly. Yeah, I mean, that kind of reinforces again what I think everyone has been agreeing. It's a case-by-case analysis that's required. The point I was asking about really was just whether that confirms what I think we were talking about earlier on in the week as to the technology is moving towards bigger machines, and some of the points Mr. Trinick was asking Ms. Anderson about in regard to some of the other or more localised policy documents and how realistic they might be. And I think paragraph 23, this is dealing with the issue about efficiency and I think routes to market and actually getting these things built, which I think is a criticism of some parties that there is quite a significant pool of unbuilt but consented schemes around. And paragraph 23, many of our stakeholders equated or interpreted the concept of efficiency as strongly, if not wholly, related to the increasing size and power of wind turbines. We acknowledge that onshore wind technology and equipment manufacturers in the market are moving towards larger and more powerful, that is, higher capacity turbines. These, by necessity, will mean taller towers and blade tip heights. So this appears to be a government recognition of what the applicant was saying yesterday. I think it was that that's the way things are going. It does, of course, then, paragraph 24, as Mr. Kelly will point out if I don't say it, technology shift towards larger turbines may present challenges when identifying landscapes with the capacity to accommodate them. Not all of them will be suitable, of course. It does go on to say, I don't think it's relevant to this, however, fewer but larger turbines may also present an opportunity for landscape improvement. That's obviously geared at repowering of existing schemes, which we're not dealing with now. But so really my question was really, this appears to confirm that the Scottish Government is of the view that we are going to be looking at bigger turbines from now on going forward. Is that fair?
Yes, I think that is fair, and that is how the market has been responding, in particular to the changing fiscal support position that we're covering on the agenda, and we've got a few points to make on that when we get to it.
I'm not sure that's quite what the statement says. You'll see that the genesis of paragraph 23 is the views of stakeholders. Stakeholders, of course, are the wind industry. And all the government does is acknowledge that technology is moving forward towards larger machines. It doesn't with respect, it doesn't express support for that changing technology. And we haven't seen a flood of decisions, although we have seen a flood of applications for larger machines. We haven't seen a flood of decisions, although there have been some, I accept, for very much larger machines. So it would be wrong to characterise paragraph 23 as an expression of government support. Properly read, it's an acknowledgement.
I don't think you were saying more than that.
Well, we are seeing, just one example, Hadshaw Hill, 26 turbines at 80 metres to tip is now being replaced by 14 at 200 metres. That's been through committee in South Lanarkshire, no objection. SNH has no objection. It's now with the Scottish ministers. It's one example of a massive increase in yield that can be achieved. So there are probably 15 or so examples I've been involved in where consents secured in the CFD world when subsidy was available are now sitting there lifeless because they cannot proceed unless they go from, say, 125 metres to tip to 149.5. And that increased height gives a new lease of life. It makes them viable. And that's why we're seeing a range of applications coming forward for tip height increases.
Could I just draw attention to paragraph 25? We've talked about 23 and 24. Paragraph 25, to me, brings about that balance and the discussions that have taken place earlier in the week. So it acknowledges what's said in 23 and 24. The government fully supports the delivery of large wind turbines and landscapes judged to be capable of accommodating them without significant adverse impacts.
Yes, I was going to come to that point for two reasons. First, given that the reference to large comes after the previous reference to larger than before, maybe perhaps that is indicating support for larger, I don't know. But as you say, quite rightly, not at any cost. I was also interested, the second point, in the use of the phrase without significant adverse impacts, which is usually something to which Mr. Bell takes great offence, but it does appear to appear in the government's own publication. I wonder if you had anything to say about that.
I think it's unfortunate language, but I think we've been over this territory before, and I know with Mr. Campbell, a few other inquiries. And, we know commercial wind energy schemes will result in significant adverse impacts. I think if the term unacceptable impacts was in there, it would be probably better. But I think that argument over this language has been ventilated quite a few times, and I think we know that it's either unacceptable or without significantly detrimental impacts, such as Highland Council used that language. It would be more appropriate.
Yes, just to add that I think looking at Highland Council's policy 67 is actually quite useful, because it does use this concept of significant detriment, acknowledging there can be significant impacts without giving rise to that higher level of impact.
Significant impact without giving rise to a higher level of detriment. You said higher level of impact, but what? Sorry, can I ask a question? Can I ask a question through you? Does my learned friend mean significant detrimental impact? When coming to judge acceptability, in whether in landscape terms or overall in planning terms, does he mean that impacts can be adverse and significant but still acceptable?
Yes, I do mean that. What I mean is that we need some phraseology which takes us beyond the word significant impact. I think the phrase used by Highland Council is actually quite useful in that, in acknowledging there can be significant impacts falling short of something which might be unacceptable.
Judgment then would be whether the significant impact is either positive, neutral or negative, wouldn't it, by definition?
I don't think anyone is saying that wind turbines have a significant positive effect.
Well, some people do. And,
well,
you know, if you like living near them, that's fine, and you can express a positive view because you see them as an expression of, in inverted commas, good for society. But surely the judgment that we have to make in the face of language like Highland Council's Policy 67 is to say, all right, the impacts will be significant. They may be judged to be adverse, but nevertheless, for other reasons, they may be acceptable, such as a massive contribution to the national grid or some other contribution. So,
Taking a point further than I wasn't looking at the planning balance at all. I'm simply looking at the concept of impact and detriment. I wasn't going into the planning balance.
You can see that having articulated as they do, at least an acknowledgement that Mr. Bell says support for larger machines, the Scottish ministers then say that individual decisions will be considered on a case-by-case basis and that they will continue to monitor, they look for full and transparent identification of impact. And then the authorities, whatever they are, will continue to monitor the challenges and opportunities arising from proposals. So perhaps we could leave you with this, that the onshore wind policy statement isn't all in one direction of travel. It's cautious, and as we might expect in a planning inquiry, it invites you to proceed on the basis of individual localized circumstances.
Sir, can I just make one comment? I'm not sure where it would have come up on your agenda. In the hearing statement for Save Wild Moray, I postulate the view that the arrival of very large turbines, thinking 200 metres plus, turbines for onshore sites is a national planning issue that should be looked at as such rather than a case-by-case basis. We have put that directly to the Energy Consents Unit, to ministers and to Scottish Government's Chief Planner. The hook for following through in that, sir, comes from the highlighted text in paragraph 26, which says we will continue to monitor the challenges and opportunities. I'm not aware of any monitoring report actually having been published by anyone, but that was the hook for the point we make on behalf of Save Wild Moray. So, thank you.
Thank you. I was going to ask, because I honestly don't know exactly what that means, that emboldened. We will continue to monitor challenges and opportunities arising from proposals with larger turbines as applications come forward, and to consider whether any future action might be required. I don't know if anyone actually knows what that future action might be. Is it action to confirm that the government doesn't like them, or action to stop councils standing in their way? I don't know what it means.
I think, sir, it might be a throwback to some ideas floated in the draft documents where thoughts were set out as to whether operators should cooperate more in selecting sites, work together, whether sites should be allocated in planning documents, etc., etc. The Scottish Government rejected those approaches in favour of the continuation of the case-by-case approach. approach. But I think as a caveat, it said we will continue to monitor the challenges. So I think that's where it comes from, sir. But as I said, I'm not aware of anything having been published.
So from my perspective, I have no idea what it means in paragraph 26. I think it's all guesswork in this inquiry, not necessarily helpful.
The next point I wanted to take from the onshore wind policy statement was on page 15. It is really looking at, I think it was Mr. Campbell's query as to the adequacy of the network to actually take advantage of the capacity of more and more renewable energy schemes. I'm sure we'll come on to issues about how much electricity Scotland needs, etc., and how easily one can export it, etc. So there's a section in the 2017 document about networks. There didn't appear to be anything specific about or any specific government policies or priorities to do something to improve the network, perhaps because it's not the Scottish Government's role. There's talk about working with network operators, the network infrastructure providers, energy stakeholders, and the regulator. Dealing with network charging arrangements. These are all matters with which I'm far from fluent, but I think Mr. Campbell's point is, and correct me if I'm wrong, that simply building more capacity is not actually helping anyone if you can't put the electricity where it's required. I'll ask you if that's right first, Mr. Campbell, then I'll give it.
It's very helpfully set out by Mr. Bell, chapter 2.7 of his inquiry statement, where the email, I think we were invited to comment on your agenda, and I simply submitted this question for consideration. But Mr. Bell has helpfully set out the content of the email and the proposed question. And his response to it is that I hesitate to call it my argument because it's not very well developed, but he says it's entirely flawed. He says that at 2712 and again at 2716. It's an entirely flawed approach, and he gives the reasons for that. But beyond supporting national and local policy for renewable energy development, I'm not sure that I understand why the question is entirely flawed. The proposition which comes before the question is, what is the point of granting consent to a development for which there is no need and no obvious route to market? Mr. Bell's response to that is, well, the target hasn't been reached yet. The target is continually unattainable because it keeps getting away from you and it keeps increasing. Therefore, you should go on building renewable energy development. Well, fine, I understand that, but it doesn't seem to me to be wholly logical when you can't actually find a route to market. I would have preferred Mr. Bell's response to say, well, actually, there is a route to market for this, and there is grid capacity. And then I would really be silenced, I think, because I wouldn't have an argument. So I hope the question is a legitimate one, and I would respectfully, at the moment, we don't have a proper answer to it.
So, come on and deal with that point. First of all, yes, there is a grid connection offer for this development with a connection date of October 2021. So we have a route to grid. The position of the applicant also is there is a route to market. We don't need subsidy, it can be built. So those 2 points are put on the table. My more general point is I think we're in danger of confusing macro with site-specific points here, that I think what the government is saying in paragraphs 55 onwards in OWPS is, yes, we recognise there are going to be grid challenges in achieving our objectives, and we will take action to meet those challenges. That's at a policy level. That's at a need case level. It doesn't look at Paul's Hill. Paul's Hill has grid connection and a route to market. OWPS 55 onwards. Yeah. So I think we have to be careful not to start to look at macro statements and try to apply them at a local level in this inquiry. At that local level, I put two things on the table.
Is there anything else anyone wanted to bring out of the OWPS? Mr. Bell?
A few brief points. I think the point I would make is it is part of ever stronger advice coming from government. It's also important, I would say, to note that the language used, vital, crucial, and so on, is demonstrably stronger than what we have in NPF3 and SPP. So, and taken in the round with the energy strategy that we're just coming on to, my view would be that the need case has materially strengthened with that. And if the view is that, yes, it has, then that must carry some weight, some positive weight in the balance that has to be struck in the case. And as we'll come on to, especially noting that the site we're dealing with at the inquiry can be regarded as Group 3 for the purposes of SPP. So that hurdle has been crossed in terms of acceptance as well. And we'll come on to that site detail. That's it.
Mr. Bell's inquiry statement fairly summarises, from his point of view, the positive aspects of the onshore wind energy policy statement. Forgive me, I'll just find it in a second. Page 50, beginning at 5.4.41, and it reads onto the second page. Understandably, but with respect, not in a balanced way, it looks at the positive aspects of the policy statement from the point of view of a wind developer. I would ask you to note also Chapter 5 of the same document, which is quite short. It's on page 18 of the onshore wind energy policy statement, and what it's entitled Protection for Residents and the Environment. Now, it doesn't say anything new that we haven't seen before, but it does emphasize that as part of the policy matrix, which must be applied to decision-making, that onshore wind development should be compatible with the interests and protection of Scotland's environment and residents. It tells you what's been considered. It tells you that the government believes that the ambitious goals are very much in the interests of Scotland's citizens, but that a balance must be struck. And there's reference to a couple of reports. In 77, which is the last paragraph, which is about wildland. Actually, no, that's 77 is not relevant. So just to say, the policy statement, though generic and strategic, also contains this quite mild caveat, but nevertheless important. And we see that reflected in local policy and earlier on in SPP. I'm frankly a little surprised that it doesn't find a place in Mr. Bell's report. It should have done.
I almost asked a question on this section, then didn't. I mean, there were two things struck me on this. The first was the, and I'm sure people will agree or disagree with it, but the findings by Climate Exchange that wind farms don't harm your house prices, etc. And as we know, house prices are none of my business. But that was people will take from that what they will as to what effect these things actually have. But the other perhaps more interesting point, which was in paragraph 74, to which you referred, Mr. Campbell, was there is specific reference in striking the right balance between utilising Scotland's significant renewable energy resources whilst protecting our finest scenic landscapes and natural heritage. And I wondered whether that was intended to differ from the approach in SPP, which is to protect NSAs and wildland generally and national parks, to give that an elevated level of protection, obviously none of which applies to this site. I couldn't find that it was saying anything more stringent than that, which actually doesn't really. I'm not saying there's no need to weigh the balance, but it seemed to be simply restating what's in SPP, which is effectively a strong steer away from certain areas, certain designated areas. I don't know if you agree with that.
I think I must, because the use of the word finest, by definition, must apply to those landscape areas which have got high levels of designation, at whatever level, starting with the National Park and working down. Is that what the author means? I don't know. It might be characterised as rather careless use of language, but you don't need. It's not an English lesson. I mean, we must apply common sense to this. SPP predates this by 3 years, but SPP is still with us and not so far either in consultation or in draft. Do we see any revision? So. For everybody who lives in the country, what they look at is the finest landscape, whether it's designated or not. I mean, you could look at it in that subjective way, as indeed my clients probably do. So could we leave that as a matter of submission?
If it helps those submissions, we don't read anything more into that paragraph than it reflects what SPP says.
Did you want to say anything about why you hadn't referred to that specifically, Mr. Bell? Nothing from the Council on this document before we move on?
No, sir. I think we've covered the points we wanted to.
Thank you. Okay, if we move on to the Scottish Energy Strategy, CD 6.2, also published December 2017. I had far fewer queries on this. To my understanding, this document still stands. It's still an expression of the strategy of the Scottish Government towards energy. But I wondered to what extent perhaps it's been overtaken by events, Climate Change Committee, and then the responses from First Minister and various others to that and the bill. So really my question is really in advising ministers the weight to give this. Has anything changed since it first came out? And of course, in addition to the obvious question of what weight do we give this, what relevance does it have to the question which we've kind of covered already with Mr. Kelly's point and the discussion we've had about, and Mr. Campbell's contribution about policy and the implementation of policy, etc. So, has anything changed? I'm looking at Mr. Bell to start with. Has anything you think changed since 2017 and the strategy that was set out there?
I think there's two points on targets, I would say. One is that the energy target will remain, because the 50% target introduced in the energy strategies for renewables by 2030. And the new net zero target covers not just renewables but low carbon sources as well. So that target remains. What may change is the renewable electricity quantum that is necessary, because although the energy strategy talks about the target being the equivalent of 140% of consumption, we know in the programme for government that the government is going to reassess what the contribution needs to be to achieve net zero, and that will be in the next energy statement. I think the remaining points I would make on the document are that page 41 talks about renewables providing the foundation of the energy system. It repeats the language of vital contribution for onshore wind, page 43. But also on page 43 says onshore wind must continue to play a vital role. That means increasingly the extension and replacement of existing sites with new and larger turbines. So again, we get that recognition of what will be coming in terms of onshore wind development. And page 69 talks about the strategic priority of implementing the onshore wind policy statement. So these are the main points I would observe on it.
Does anyone else want to tell me anything about Scottish energy strategy?
It's not concerned with protection of locations. It's concerned with protection of consumers. And that protection is centred around protection from excessive costs of energy and the promotion of the benefits of renewable domestic energy applications and systems. I'm looking at page 7. There are summaries, and that's developed inside the document. So, whilst I understand what Mr. Bell is saying in relation to the force of the language used and so on, I think with respect, so far as my client's concerned, this is not a document, the rules of which have particular application to this case. Because I can't find anything about protection of landscapes or protection of domestic community, residential community. It just doesn't seem to be there.
I think that's right in terms of its content. The other aspect that we did touch on earlier in the discussion was the electrification of transport and heat, and that's very much what the document does cover in terms of the scenarios looking to 2050.
Can I just say, sir, I think it's something I've been guilty of myself in the hearing statement, but I just get the sense that because this is nominally a Section 36 application, we are being drawn into quite a wide-ranging debate that could go on for hours and hours without actually reaching any conclusion. And at the end of the day, I do feel we have to come back to the fact that this is a 7, possibly 6 turbine development that really raises local issues. It's not to say that your report ignores these wider considerations. They are material, but I think the bulk of your consideration has to be the local issues in terms of policy effects and benefits, or else we could be here till Sunday, never mind Friday. Thank you.
Yeah, I'd agree with Mr. Kelly. I think we're in danger of going round and round in circles here, because I'm about to point out on page 43 the reference to the right development in the right place yet again. So we're going to continually identify that balance as we work through these national policy documents. I think part of your question was what's moved on. Well, I think I was going to say I think quite a few things have moved on from this statement, and that's embedded in the programme for Scotland Again. So some of those sectors that we talked about that are lagging behind, I think that a very clear commitment to move those sectors forward.
If I may just respond to Mr. Kelly, I think he's fundamentally wrong, and the debate we're having at the moment about the direction of travel of national policy, and Councillor just acknowledged this, is a vitally important component in decision making. It's called the need case. It's called the other side of the planning balance, and where that need case is going is a vital part of this inquiry. So I'm sorry if we're keeping him awake, but this is a vital debate. I wouldn't want to see it curtailed at all.
Said I was wrong to say that there is no reference to location. Page 43 has that reference.
If I can just respond to Mr. Trinick on one point. We have differing views, but the problem I see is if you start to want to go down the route of a great consideration of the need case, it begins to bring in all sorts of other considerations, such as the number of turbines that have been consented but are unbuilt. So should the need case or satisfying need for more generation focus on why they have not been built as opposed to consenting another 6 turbines? I also think that the way many of these documents are written is quite deliberately balanced. There's always a caveat or a nuance to them, and I don't think that hours of debate will produce any definitive answer as to what they mean for your decision. And that's simply the point I make. I do not intend to downplay the documents or the direction of travel. And as Mr. Templeton said, I think there's some very interesting developments likely to come forward through the programme for government, but we have to wait and see how they develop.
So I know we'll come on to it, but what the message is from government is really, and internationally, we not only need the 7 gigawatts that was unbuilt, but we need a lot more than that. And in a state of climate emergency, it's of critical importance that these material matters are aired and reported to the ministers. So, I can't understate the importance of the topic and how it's reported accurately, because the applicant is the only party that brought this information to the inquiry.
Okay, so we can continue to make some progress. Committee for Climate Change, I think, was the next thing on the agenda. Let's find it. Yeah, recent recommendations from the Committee on Climate Change. Had a number of points that sort of jumped out at me from this. I suppose, though, first question really is, what direct relevance is this, given that it's not a government not government policy, it's not government anything, it's a piece of advice commissioned by the UK government, I believe, and it offers a series of messages which need to be considered and possibly acted upon, depending on what the government wants to do. So just before we look at some of the points that jumped out at me from it, what importance does this document in itself, rather than subsequent responses to it, have, Mr. Bell?
I think the content of the document is important and relevant, and as you allude to, it has informed the UK and the Scottish Government's subsequent actions, which is amending legislation and statute to take on board the full recommendations. So it's not just policy, it's law. And I'll defer again to the advocates in the room on that, but the legal position is that these are now targets.
Is it fair to say that I've not seen, and there's nothing before me to criticise any of the sort of science that has informed the committee's production? Nobody's challenging that the work that went into that report is somehow flawed or overly pessimistic.
Not on this side of the Atlantic.
Okay, so I think we know what the committee were recommending, net zero targets and things, and as Mr. Bell says, and as we'll come on to, that's led to action by UK and Scottish governments. I was particularly interested in the technical annex that deals with variable renewable technology, given that that's what we're looking at here. I confess I've now forgotten the core document number for that. Thank you. 626. Actually, maybe 627 now. 626, you're right, is the actual document itself, but the technical annex, I think, is 627. Yes. I'm interested in what people think about this, in that it seems to address head-on some of the concerns a lot of people have, quite understandably, about intermittency of things like wind and solar, and how the wind doesn't blow all the time. Sometimes it blows when you don't need it. Sometimes it doesn't blow when you do need it. And if you have a system that relies upon an intermittent component, necessarily you need to have other systems in place to ensure that the lights don't go out. What interested me was how this section, this technical annex, deals with all of those concerns kind of head-on in the context of trying to decarbonise the overall energy system. Notes that I made from it, phrases such as intermittency of renewables does not prevent full decarbonisation. Costs of intermittency represent a small proportion of the overall system cost. It appeared to me to be suggesting that concerns that we might have about the intermittent nature of things like wind are not necessarily going to impair the desire to move the whole generation system into a low carbon basis, and whether that involves nuclear or carbon capture and storage or all sorts of other technologies like hydrogen gas. I just wonder what we can take from this. It's quite an interesting technical study. Obviously not anything happening immediately, or perhaps it is, but it appears to be looking a long way into the future. But it's I'm interested to see what people think as to what this tells us about the issue of intermittency, which obviously is a concern with things like wind and what value it can actually bring overall. I'll start with Mr. Bell.
Thank you. I do touch on it briefly in the hearing statement of 2211, but the document does start by being very clear that large-scale onshore wind is the cheapest form of electricity generation in the UK. It can be deployed at scale to meet demand. The key message, it says, on intermittency of renewables is that it does not prevent full decarbonisation of the power system, and deployment of variable renewables alongside system flexibility, smart grid, is a low regret and low cost means of decarbonising the UK electricity system. And correctly, it does, as you highlight, so it does say that in terms of the scenarios for the future, renewables could take 57% for the UK, but that may also see low-carbon power from nuclear plants with carbon capture and storage playing a role as well. And the policy implications section of the paper does say that the scenarios for 2050 taken by the Climate Change Committee assume a penetration of 57% of variable renewables. So I think this puts to bed the common allegation of wind energy is ineffective. The CCC is saying, look, the system can't cope, it's moved on, and the flexibility allows for large-scale deployment, and that is what is in the scenarios. And that is, in turn, what has been taken up by the Scottish Government in the net zero acceptance, which is now in law.
Anybody have any comments on this technical document?
No, we've provided no evidence on this aspect of the matter, so it would only be me giving evidence which you don't want.
Of note, on page 7, it shows the variable share of renewables around Europe. And Denmark is at 50% already. That's in 2015. And the UK is down at below 15%. But it just shows that it can be done. And I think the CCC is recognising that clearly that there's confidence in it such that it is low regret.
Okay. Anything else anyone wants to say on this document? Okay, can we turn to government responses to that report, the CCC report? Scottish Government's response, UK Government's response, and I actually had a question as to what, I'm afraid I've been slightly out of the loop as to at what stage climate change bill had reached. I'm suspecting it may have become an act now, but I don't know. I'll have to turn to Mr. Bell first. I wasn't referring specific to a document. I was referring to a sort of the collection of responses to the Climate Change Committee's publication of 2019, earlier July and May, I think it was. So it's Scottish Government's response and UK Government response. And I think within this heading, possibly, is the logical place to look at the programme for government as well. That's a very recent publication that does refer to the issue of the climate emergency and things like that, as well as other things. So maybe we include that in the list of documents. But I suppose the first question really was what is the legal status of the response, I guess in Scotland in particular?
the position is that the amendments are being made to the Climate Change Emissions Reduction Targets Scotland Bill. Bit of a mouthful. And that bill will amend the Climate Change Scotland Act 2009. And the bill was introduced by Cabinet Secretary for the Environment, Climate Change and Land Reform, Rosanna Cunningham, MSP, 23rd of May 2018. My understanding is that the bill completed stage 2 in Parliament on 25th of June this year. Moving on to stage 3, that's the latest that the Scottish Government website states on it. So it will be amending the Climate Change Scotland Act 2009. That will contain the net zero commitment.
So it's certainly anticipated after the summer that bill will pass and it will become law before you write your report.
There's also the UK position. I've set that out at 239 in the hearing statement, where there is an amendment to the Climate Change Act 2008. That has been made, that's my understanding.
And as I recall, Scotland has been slightly more ambitious than the UK in that we're setting a 2045 target for achieving net zero. Is that right? Instead of 2050? Is that?
Yes, that's right. It was in the CCC report, and it's also reflected in the legal position in terms of the 2 dates, in those 2 elements of statute.
As I said, there's reference to it in the programme for government for Scotland, which doesn't appear to have page numbers. The document, it is APP 12, which is the Protecting Scotland's Future Government's Programme for Scotland 2019-2020, and it does have page, no, it occasionally has page numbers. I think it's page 10 that I was looking at in the executive summary, ending Scotland's contribution to climate change. And again, that reflects the 2045 net zero deadline. Yes. The other document I wanted to just think about was CD 631, which was the annual energy statement from Scottish Government 2019, because again that refers to the report of the climate change committee? Yes, 6:31. I don't know yet. Several. I'm just looking at what in particular I... Right. Thank you. Sorry, a lot of documents there, and really my question was, is it fair to conclude that the response of Scottish Government is very much to accept the Climate Change Committee's advice as to the seriousness of the situation, the apparently poor performance against previous targets, let alone the new targets that have been proposed and are now about to become law, and the question being, well, what relevance does this have to the proposal that is before ministers? And I think it's all part of the same question, as I know Mr. Kelly is going to tell us again quite reasonably that this is a very small proposal in the grand scheme of things, but I suspect Mr. Trinick will say, well, it's about the direction of travel in terms of applying the weight in the planning balance. I really just want some guidance as to what, how I should take account of all of these developments. Scottish Ministers, First Minister's announcement of a climate emergency is another example of the response to this, and I think similar things happen down south as well. What's it? How, if at all, does it help me in the decision I need to make?
I think in the programme for government, there's quite a bit in there. I'm not going to go through it all, but one point strikes me as page 35. It says, this programme for government commits to vital early action to accelerate our journey towards net zero. So the CCC is saying we need to act now. That's what government ministers have said, and that is really what the programme for government is saying. And in my hearing statement, I've set out that when you take these documents in the round, that's the CCC recommendation, and the Scottish Government seeking what they call transformative change, action has to be quick and decisive. They've called a climate emergency that requires action, and decisions through the planning system, I would say, need to be responsive to that position and to bring these highly material matters into play in determinations. And therefore, if the various documents we've looked at this morning are material, they must go to the matter of weight to be attributed to the project benefits and the need case for Paul's Hill 2. And I think what was striking in coming to that conclusion, in the Council's hearing statement at the end, it's paragraph 4.1, it states that the statement highlights the most relevant national and local policies, and it sets out the status of these policies and provides an up-to-date view on the weight to be afforded. It refers to it as a position when the decision was taken on the application. Now, things have moved on considerably, and I would say, and we'll come on to it, that NPF 3, SPP are 5 years old. Even aspects of the LDP are being overtaken by events. And the government view has changed dramatically over this year with the new targets being introduced. And I would say that global heating is not just an abstract scenario in a report, and that's evident from the programme for government that has just been issued. And with net zero and the declared climate emergency set out in that document, it's clear that the government wants the ambitions translated into real action. And it talks about the planning system being a critical tool in that. And I think that must therefore come down to a matter of weight that is given to these considerations in the case.
I'm playing tag a bit here. I want to add to that, just to draw together some threads here, that policy and action to implement policy is developing extremely rapidly at the moment. Mr. Kelly said we're drifting into a future policy discussion. It's not future policy. We're actually talking about to be current law. We're talking fast emerging policy, which is relevant to this inquiry because it relates to the need case. And I'll be saying in closing submissions that NPF 3 and SPP 2 are already way behind the curve. The onshore wind policy statement and the Scottish Energy Strategy are really interim catch-ups, which are already themselves slightly behind the curve. NPF 4 will need to reflect not just what's happened in the past, it'll need to reflect the Climate Change Committee report. It'll need to reflect net zero, the climate declaration of climate emergency by the Scottish Government. And interestingly, the 28th June declaration of a climate emergency by Murray Council with its intention to become carbon neutral by 2030 by Murray Council itself. It will need to reflect the Scottish Government's programme. So what we see is a rapidly emerging, very new position. It's not business as usual anymore. And that means that phrases, true there they are, like it's case by case, the right development in the right place, that may well be true. But the need case on one side of the planning balance is acquiring significantly greater weight month by month with the developments that are occurring. And that is the importance of this topic, to this inquiry.
I'm just waiting for you to stop writing. If that were 100% correct, we wouldn't need planning inquiries, would we? Now, what we need to remember is that the programme for government, distinct and clear though it is a political declaration. So it is the policy of the government as untested so far and not, I think, approved by Parliament in the sense, if you're asking yourself the question, well, what governs my decision? What actually governs my decision? You'll start, I know, with the Electricity Act, you look at the local plan, and then you look at these other material considerations. And I don't for a single second say that they're not material, but giving weight to the programme for government as if it were some tablet of stone delivered perhaps on the top of Lloyd's Hill, that's a very bad joke, I'm sorry, would be wrong. It's material, you should notice it. Clearly outlines an imperative in the mind of government. Does it dictate decision-making? Well, I respectfully doubt that. But there are plenty of legal parameters within which your decision has to be taken. And it's as true today as it was when Marcus Trinick and I first met in 1994 that you have to look at the individual circumstances of the application to see where the balance lies.
I don't think anyone was questioning that, but do you accept Mr. Trinick's point that in terms of the weight on the sort of need side, the positive side of the balance, all of this, not just the programme for government, but other things, recent developments, is tipping the scales to some extent in favour of his side of the argument? Do you accept that point?
Well, I think the scales began to be tipped with what was it called? NPPF 6, National Planning Policy 6, which was the first statement of, have I got the name right? NPPG, thank you, I'm obliged, which went through a couple of iterations before we saw the first version of Scottish Planning Policy. And the second one, Mr. Trinick's quite right, it's 5 years old. It's about to be superseded or re-edited or republished. Whether there'll be consultation on it, I don't know. And to some extent, it is behind the curve in the sense that it doesn't quite marry up with modern statements of policy. The phrase climate emergency, I don't criticize it, but it's a political phrase. It's designed to give prominence to what is seen as a policy imperative by the Scottish Government. Whether those policy imperatives should govern your decision, I think you have to ask yourself very carefully. Does it swing the pendulum away from the possibility of either qualifying or refusing an application for renewables in a particular location? And actually, I don't think, with respect, it does. In a way, these policy statements from 2014 onwards all state obvious truisms that you can't develop in a situation where you cause positive harm to neighbours, even at the cost of some perceived benefit to society. You can't do that. So, with respect, don't agree entirely with Mr. Trinick's rather one-sided view of this. I think he needs to take a much more balanced view of the competing considerations.
I was going to ask you, by all means, respond to that point, but if you also wanted to bring out anything else from the programme for government, because I know you referred to it earlier, by all means do.
Yeah. It's a rather cheap point, but I was just struck by the absence of any reference to onshore wind in it.
Yes, I was also struck by that lack of reference to onshore wind. There is a graphic on a turbine, but and references to offshore wind and various technologies, but nothing on onshore wind. Just to pick up on Mr. Trinick's point as well, and agree with Mr. Campbell that we understand the climate change challenges we have. Nobody's disputing the need and the challenges ahead, but we're not saying in any way that we meet that need at any cost. And meeting that need, we shouldn't be compromising other environmental interests. And I think in terms of the programme for government, it does endeavour to address where we're going, the challenges that we have, the changes in policy situation, and identifies quite clearly the National Planning Framework 4 is in production. A series of workshops very live at the moment or in the next month or two. And I see that as being the framework for addressing these challenges.
Before I come back to you, Mr. Rowell, in terms of MPF4, I'm showing my ignorance now, despite being employed by the Scottish Government. I don't actually know what's going on with its production. I don't know if you know. I know the new Planning Act talks about, I think, sort of parliamentary scrutiny. That would be if it was prepared under that Act, but if it's not prepared under that Act, then perhaps it can just come out as did its predecessor without that stage. I have no idea. I'm just in terms of timing. I don't know. If anyone knows, please please tell me.
I don't know, but I do understand that the new Planning Act is not yet enforced and that it's anticipated that it may be a number of years before subordinate legislation is introduced to bring it in. Rather, it's happened in 2006. Mr. Kelly was better informed than I am.
I know Mr. Templeton wants to speak. One point I take from the discussion is that planning policy has fallen well behind the curve, and I do agree with Mr. Trinick on that point. And just as an aside, the Scottish Property Federation Planning Committee met with the Bill team prior to stage 3, and that was a point that was made very, very forcibly to the Bill team that the planning policy, the planning system is being left way behind in these very important debates, and there's a desperate need for an updating of policy so that we don't continue to have these debates at every single inquiry for the next 4 years. So there's no dispute on that from my part.
Yeah, I was just quickly flicking back through my notes because I did attend a Heads of Planning meeting a couple of weeks ago where it was discussed. My understanding is the Scottish Government are working through their various work programmes in September. I understand there's workshops coming forward in the next couple of months, certainly, about NPF4. And I think, but I can maybe clarify afterwards to all parties, I think they're talking about having something out for consultation and discussion early next year, but I'll endeavour to clarify that. There's actually a meeting this afternoon of the North of Scotland Development Plans Forum, which, depending how this hearing session goes, I might be able to phone into, and I'll get an update from the Scottish Government at that point and can circulate that.
Mr Bell, do you have any knowledge?
I've got a bit. I think that's helpful from Mr Templeton. It fits with what he says. That I heard the Chief Planner speak at a conference just a few weeks ago, and he said they were waiting for, because one of the questions was, how will the planning system deal with climate emergency? And the Chief Planner's response was, we need to wait firstly for the programme for government, and then that will inform different public agencies in terms of their response. And I think this document does talk about, that's the programme, engagement on NPF4 this year, with a draft coming out in 2020 for consultation. I think the point was made that this document doesn't refer to onshore wind, the implication being it's not as important as the other technologies that are referred to, if I'm reading that correctly. But you're right, onshore wind is mentioned, but I think the parties missed the point that offshore wind is referenced, and the action coming out of it is that there will be enough offshore wind policy statement prepared. But the government's already prepared the onshore wind policy statement. That was the first one that was done. It's the first technology that was addressed by government. It's the lowest cost one that can be deployed at scale. And what is referred to at the start of the section on energy is that there's a general statement that renewable energy sources play a key role. So the government is not discriminating in terms of different technologies. The fact is, onshore wind was prioritised in 2017 and is now to be implemented. So I think there's other points to make on this, but they're detailed ones. I think the main message is probably covered in terms of the climate emergency and net zero within it.
Well, I think, if I may ask a question through you, can we then understand that the applicant's case to some extent is perilled on the 2017 onshore wind statement? And the programme for government, interesting though it is, doesn't innovate on that, and I think I would like to know if you're resting your case there, because if you are, we can then address that in the closing submission.
The document's very relevant in terms of what we've talked about this morning, in terms of the position on net zero, climate emergency, and the overall position on renewables coming forward. And the detail on onshore wind remains in the onshore wind policy statement.
Sorry, could I just add, I found my notes and it says summer 2020 for draft NPF4.
That's helpful. I'm aware that the new planning act will take a while to come in, and it will come in stages. But I just wondered whether a decision to crack on with NPF4 and under the current act and not therefore put it before Parliament might have been seen as undesirable, and therefore they would hold fire, and in which case it could be years away. There's a balance there as to which is the worst of the two. But that's very helpful. I should have known that, but glad for that. Do we need to say anything else about the responses to the 2019 Climate Change Committee's findings. Anything else anyone wants to say before we move on? No? Okay. Should we take a 10-minute break to get a breather? And then we shall get into things that some people may think is a bit more interesting and or relevant, starting with SPP, NPF3, and then moving on finally to local development plan, supplementary guidance, landscape capacity. It's 20 past, so if we could just 10-minute break, come back at 11:30. Thank you. National Planning Framework 3, NSPP. I might as well do NPF3 first, as I've got that first in the order. You may be relieved to know that I have far fewer questions or points I wish to raise on these. I think the more familiar we all are with the document, perhaps the fewer questions arise, but don't let that stop anyone bringing out points that they want to make about these documents. MPF3, to me, says two interesting things. There may be other interesting things people want to bring out, but it's document CD 4.2, if anyone doesn't have it. There are two phrases I just wanted submissions on. At 3.23, there's confirmation that onshore wind will continue to make a significant contribution to the diversification of energy supplies. So that's a statement of some support, whereas earlier on in the document, 3.9, in time, towards the bottom of 3.9, in time we expect the pace of onshore wind energy development to be overtaken by a growing focus on significant marine energy opportunities, including wind, wave and tidal energy. Are either of those statements particularly helpful or contradictory, or perhaps even have they been overtaken by events in any case? Mr. Bell, I'll pick on you first as you're nearest.
Thank you. I think 3.9 is, in terms of capitalising on wind resources, a consistent theme we're seeing carried through to today. In terms of the pace of onshore wind being overtaken, we haven't seen that. Onshore is certainly growing, but in terms of marine opportunities, there's been delays to Maygen and various other projects. And it's clear from the onshore wind policy statement that onshore wind has a clear role for the future. We've covered that this morning. The other point I would make about NPF3, the targets referred to at 3.8 are clearly been overtaken by events. And I think the phrase was used this morning, behind the curve. I think that is a fair reflection of the document and its content when you consider the climate crisis, global heating, the climate emergency that we've already covered this morning. And I think the last thing I would say is the Programme for Government document, page 39, does say that the government will be exploring more radical planning policy options and states planning as a vital tool in the changes necessary to achieve the government's goals on net zero. So, again, that's looking ahead to NPF4. So there will clearly be changes compared to this document we have today, NPF3.
Sir, as always, it's necessary to read the whole document and have regard to the balance. Paragraph 4.4 says Scotland's landscapes are spectacular, contributing to our quality of life, our national identity and the visitor economy. Landscape quality is found across Scotland and all landscapes support placemaking. That's under Scotland today, and under Scotland tomorrow in 4.7 said it recognises at that stage the pressing challenge of climate change means that our action on the environment must continue to evolve, strengthening our long-term resilience. A planned approach to development helps to strike the right balance between safeguarding assets which are irreplaceable and facilitating change in a sustainable way. So I think the document just takes us back to what we discussed before. There is a balance. But I think what in saying that, the basic point must also be recognised that it is now significantly out of date.
Does anybody agree it's significantly out of date, Mr. Cromwell?
I'm afraid I don't agree that it's significantly out of date. It was an aspiration expressed in 2014 alongside SPP and was the product of a trawl for big ideas in the national context. Now, as we've come to understand its use, it's not site-specific, it's not prescriptive in that way, and will presumably be replaced by a document which contains different big ideas for cities and the countryside. But it contains important safeguards which are relevant to this case, and Mr. Kelly has somewhat stolen my thunder by identifying 2 paragraphs where those are expressed in a generalized way. Nothing new there. It doesn't say anything different really from SPP, which, as you would expect, is a little more detailed. But I don't see it as out of date, except, of course, that targets have changed for political reasons, and that doesn't make the document out of date. It simply means part of the document out of date. But, you know, it's a very generalized expression of will. It's only 5 years old. If you look, I mean, just for example, but it's not a particular relevance to or importance to this case. 412, the authors say, in the coming years we want to see a step change in environmental quality, especially in places with long-standing disadvantages. And that's obviously a reference to the urban environment. So, insofar as, all I want to say really is, insofar as the document contains a sort of lexicon of good ideas, I don't think you should regard it as out of date, and I don't think you should dismiss it.
So just say, I would say it is out of date. It had a 5-year lifetime, and we are beyond that 5-year lifetime. That was what the Act set out. And so it is over 5 years old, and that's important in planning terms because we treat development plans that were 5 years old with the presumption kicking in at that stage. I'm not saying it kicks in just on NPF3, but the 5-year lifetime was very clear for NPF3.
So is it the case of the applicant then, if I could ask through you, that NPF3 can just be ignored? So if that's the position, we'd like to know, and we can address you later on that basis.
No, we're not saying that. We've referred to it in evidence, but the 5 years is up.
That's the point I was going to raise, was I'm not aware of the Scottish Government telling us as a planning authority to disregard the National Planning Framework. In terms of how up-to-date it is, I think the vision is still largely very relevant as well. It gives that very balanced approach that we've been talking about. And thank you, Mr. Kelly, as well. I was going to raise paragraph 4.4, which I think is a very, very strong statement. But within the vision on page 1, we have a successful, sustainable place, a low-carbon place, a natural resilient place, and a connected place, which is all still very relevant to you.
Thank you. Scottish Planning Policy 2014, CD 4.1, I think. The notes I'd made on it, well, I suppose the first question in relation to spatial strategies and things, and it deals with this and also with the development plan, but I think Mr. Bell's point is effectively this is a Group 3 area, given that what might have put it into Group 2 is the deep peat concern, which I think is not a concern on this site. Do we? I'm not sure it takes us very far, but do we agree that that's a fair point? I'm looking at the council, really.
Yes, that's a fair point, yes, under the terms of paragraph 161 and the spatial framework, yes. I don't know if this is the right time for me to highlight, obviously, that in our statement we've said that spatial framework provided under Scottish planning policy covers roughly half of Moray, and it covers all typologies or all scales of turbines from 35 metres and above, and we therefore question how much use that is in directing the right development to the right place. And then we have our arguments about paragraph 162 and the more detailed frameworks that then follow.
Mr. Trinick.
Coming on this, we've noted what Murray say in 227 and 229, 2210 of the hearing statement regarding the relationship between SPP 161 stroke table 1 and SPP 162. I think the basic position is, as outlined just now by Murray, that SPP 161 and table 1 results in the quotes 227 very high-level strategic framework, which the Council considers to provide limited guidance or certainty to developers. And so they go on to the SPP 162 exercise, which we see ultimately in the supplementary guidance. We say that's the wrong approach. If you look at SPP 161, we know it well, but the idea is to set a national spatial framework, which we see in Table 1. I needn't go into it, we know what it says. What SPP 162 does need attention, because that says both strategic and local development planning authorities, working together where required, should identify whether a strategic capacity for wind farms and areas with greatest potential for wind energy development, considering cross-boundary constraints and opportunities. Now, first of all, I note that although we're right on the boundary with Highland Council, I haven't seen that Murray have sought to engage Highland Council in its SPP 162 exercise, unless they tell us otherwise. I don't know if they have or not. Perhaps they tell us. But in terms of the strategic view as opposed to a more detailed view, all that 162 says is identify strategic capacity. It doesn't say refine Table 1 within SPP. It doesn't say refine the spatial framework. When we look at the detail of what Murray have done, we have to go to the SG. If you get that, sir, CD44 on page 12. Yeah, on page 12. And what they tell us is what they've said in the hearing statement, that the spatial framework required by 161 results in a very strategic overview to meet the requirements of 162, and then they go on. What they've actually done then is to apply a series of constraints additional to those envisaged in Table 1 of SPP. Sustrans buffer, rights-of-way buffer, road-street buffer, rail buffer, core path buffer, key scenic approaches to Murray, RSPB spatial mapping. That I think is wholly inappropriate at a development planning as opposed to development management stage. 162 doesn't say refine the spatial approach to a local level. It says simply identify strategic capacity. And to me, that means clearly in line with Table 1 and the spatial framework. So, in our view, the right approach is to use SPP 161 and Table 1. Yes, it results in a large area of Group 3. Fine. You go to Group 3 and it says you now look at a development and management level, the detailed considerations against identified policy criteria. Those criteria can include all the matters on page 12. They come in at development management stage. So you don't muck around with the National Spatial Framework in SPP. Under 162, you simply identify strategic capacity and leave the rest to development management. The fact that Murray's saying they may have persuaded one reporter on this elsewhere is of no interest to me at all. I'm trying to persuade you.
I took the point you said the reporters supported you, and presumably in Scottish Government, I think they required a few tweaks to your supplementary guidance, but they didn't object, presumably as it's in there, to what you've done.
No, that's correct. I was going to probably rather cheekily ask through yourself whether Mr Trinnick does know that this has been adopted, supplementary guidance. It does form part of the development plan. It's been through scrutiny. In fact, it got the most scrutiny of any supplementary guidance we've ever submitted to the Scottish Government, and I'm quite happy that the Scottish Government have endorsed it's embedded in the development plan for Murray.
It's been adopted because I acknowledge that. A, we're under Section 36, so we haven't got a primacy provision here. And secondly, it doesn't make it right, and I'm entitled to ask for the appropriate weight to be given to the document.
As a matter of language, it's difficult for me to understand how you can work out what your spatial framework ought to say unless you first observe whether there are any constraints which you would leave out of your spatial framework. I mean, spatial framework doesn't ignore such matters as are set out on page 12 of the supplementary guidance. I wouldn't have thought. I mean, I'm not a professional planner, but if you take out what's on page 12, then what you're left with is where you can develop your spatial framework.
That's correct. And we've also, I think there's almost an inherent criticism that we've been somehow negative, but I think I'm not aware if other authorities have identified opportunities for extensions and repowering, and really what we've done is an exercise in the spirit of Scottish planning policy to use that again, the right development in the right place. We don't feel the broad brush approach does that. I don't know how that provides any certainty to developers and communities, and by doing that finer grain, that finer sieve analysis, if you like, of constraints and opportunities under paragraph 162, we think that's a more worthwhile exercise.
I hear well said, but whatever you may think and whatever direction you may go in, it has to be consistent with SPP. The only spatial framework appropriate is the spatial framework within SPP Table 1. It really isn't up to local authorities to say, yes, but we're going to refine it a bit more. That's a development management, not a development planning exercise. So I just don't think it's an appropriate approach. Oh, by the way, we're not criticising the effort that has been made. After all, you've identified the area of this site as being one for extensions and repowerings, and we're grateful.
We could trade these comments all day, but just to say that, reiterate again, it is an approved statutory supplementary guidance, so whether Mr Trinnick approves the approach or not, the Scottish Government have. I think that's the most relevant and important consideration here.
Thank you. And at least we're not dealing with a planning application where Section 25 would apply, and it might make things more focused. They're all factors that go into the mix. Really, my questions on SPP, again, because I'm a bit more familiar with this than some of the recent publications, are confined really to the question about development that contributes to sustainable development and the presumption in favour of that, how important that is. In the grand scheme of things, is that something over and above other policy support, assuming that this development could be characterised as development that does that? The presumption in favour of sustainable development. People may have views as to whether it is or not, but even if it is, does that actually take us further than what's already set out in SPP and elsewhere in terms of policy support for acceptable forms of renewable energy? There's also the question of the tilted balance, if and when that might kick in, which I'd like to ask Mr Bell about. That was really all I had on SPP. Obviously it says all sorts of things and there are all sorts of criteria in there, and I'm happy to hear points about any of those. But for now, that's all I had. So I think I'll turn to Mr. Bell first, because I think he dealt with it in some detail in his statement. So really, presumption, what relevance is it? Tilted balance, will that at some point kick in? And what do you say about it? Those are the two main areas. With regards to the tilted balance and the timing of the plan and all of that, I'll give you a heads up as to what I was thinking in that regard, as to, in a situation where there is another plan in the pipeline, quite a long way down the pipeline, I think, in terms of the appropriateness of the tilted balance, bearing in mind why it was introduced, if we even know why it was introduced, what does that tell you about the reasonableness of applying that at the point at which it would normally arguably apply? I'm good at these very long questions. If everyone's still awake, I'll hand over to Mr. Bell. Hopefully you understood where I was asking. If not, I'll ask it again at some point.
I'll try my best and by all means come back if I've not answered all the points. But in my hearing statement, I go through the approach to the presumption in some detail when I set out the policy principles in SPP and how, in my view, the proposed development accords with those. And I set out that, in my view, because of that performance of the development against those principles, that the development enjoys the presumption, what I've termed the first stage level, if you like. But as you rightly highlight, I think, and I'm sure Council's planners will give us an up-to-date position on the development plan emerging. I'm not sure exactly of that. But my understanding is that the current plan would fall away in July 2020. And if a decision is not made on Policy 2 by that stage, then the presumption becomes a significant material consideration as per SPP paragraph 33, because that would be the 5-year period up. And at that point, then, the tilted balance would apply, which is important for decision making, for the reasons I've set out. So that is the timing point. And I don't think the new plan would come into play before that date.
Even if it didn't come into play, if it was almost there, how reasonable do you think it would be for me to recommend, assuming I hadn't already made my decision before that point, but assuming, we're in July or August next year, and ministers are about to make a decision, and the replacement plan hadn't come in, but it was very close to coming in, how reasonable would it be to, if you like, penalise the council by applying the tilted balance at that stage?
Maybe best. I think so. The answer is if in your report you assess matters primarily by reference to the new plan as opposed to the old plan, then it would be unfair to claim the tilted balance simply because the new plan hadn't quite been adopted. That would be unfair. If, though, you assess matters primarily by reference to the old plan and gave less weight to the new plan, then I would claim the tilted balance.
Before we deal with all the other things I've talked about, just in terms of the timing, I think I'm right in saying that you've put the plan before one or more of my colleagues, I suspect. Is that, you can just give an update and any indication that they may have given you as to the timing of when things might progress?
Yeah, you're right. We submitted the plan at the end of June. We're a couple of months ahead of our schedule from the development plan scheme, which had us submitting in August. So with a fair wind, we would hope to have the examination report around March time. And at that point, just to muddy the water further, we would probably, what we've previously done is report the plan to our committee with the modifications, and we'd probably ask our committee to give greater weight to the emerging plan than it currently has. At the moment, we're giving no weight really to any policies or any sites which have outstanding objections, but anything that's free of objections in terms of settlement sites and such like has some weight.
So it may well be the tilted balance is never, even if I take that long to make my recommendation, it may be the tilted balance never actually kicks in timing-wise, but that's helpful. Can we go back to the question of what do people think about this being development that contributes to sustainable development and therefore qualifies for the presumption? I'm looking at Mr. Camel because I suspect you have something to say on it.
Well, I think I can be very brief. I think sustainability is a coin with two sides. And you have to look at the sustainability of what happens at Coglas. And if I may speak for her, Mrs. Mandel's business at the holiday cottage. Sustainability is about operating without leaving too much of a mark, which affects the next generation. And we could argue all day about whether wind energy is truly sustainable. Don't worry, I'm not going to do that. This is not the forum. But just to make the simple point, that sustainability is not some sort of halo which sits above Mr. Bell and Mr. Trinning. It is something which has two sides.
I think that's right. It's fair that there's a balance, and the policy principles are set out on page 58. There's 10, and I've put a summary position on how the development relates to each. And at the end of the day, there is the wider public interest to balance, and the policy principle talks about paragraph 27 of SPP. Environmentally and socially sustainable places by enabling development that balances the cost and benefits. And that is exactly what the planners have sought to do in the case, is strike that balance. And my view, having looked at all the policy principles and set it out in evidence, I don't think others have, I may be wrong, but stand to be corrected, is that the balance falls in favour of the benefits. And I've made the point that in all the cases I've done, I don't see this as a marginal balancing point or just getting over the line. I think all the factors do carry considerable weight, such that that presumption, I think, is engaged when one properly looks at the various principles that are relevant in the case.
Okay, and I don't expect the parties to agree as to whether the balance is as Mr. Bell thinks it is, and we're never going to get there. But as I understand Mr. Bell's argument, if I were to agree that the balance lies in favour of concluding that this is development that contributes to sustainable development, then the presumption that kicks in, I think, Mr. Bell, you say that is another aspect in your favour over and above anything else. It's another tick in your box in the planning balance. Just really wanted to test whether people agree with that interpretation of SPP, that it's another factor. It's not simply restating the balancing act. It's another tick. Just check first that is what you're saying.
I think absolutely, because it's under the development management section. And paragraph 33 gives specific direction for decision makers in terms of how to apply the presumption in certain circumstances. It doesn't say anything about this being a cautionary approach or any double counting point. It's a clear step for development management in addition to looking at policies in SPP and in the development plan.
Presumption, if I can speak as a lawyer, is of course something that can be rebutted. It's not a trick of English. A presumption is something you can presume to be the case, but it can be rebutted. And it's for you to decide how high the threshold is for that to be rebutted. What paragraph 33 of SPP says is that decision makers should also take into account any adverse impacts which would significantly demonstrably outweigh the benefits when assessed against the wider policies in this SPP. So by some mystical process, you're being asked to weigh local disadvantage against wider policies in the Scottish Planning Policy document. Now, how you do that, I think, is a matter for submission and not for today. But,
sorry.
Sorry, go on.
I think Mr. Campbell makes a valuable point, and I've always been slightly confused as to when presumption takes. Because if it's a starting presumption, but for renewables development, or when does it arise? I don't think it works that way. I think it's you work towards the presumption through the application of the principles in paragraph 8. Exactly. So, but I'm just answering a point about being rebutted. It's not a question of rebuttal or presumption. You establish whether or not the presumption applies by the application of those principles. And if you reach the conclusion it does, then it applies. But the word rebuttable assumes there's a starting presumption. I don't think there is. That may be where we differ. I think that if you... Sorry, my apologies, go on. No. I think we're at one up to the point where you've applied the principles and said you have the presumption. I think where we disagree is, I think beyond that point, you've established the presumption. It's not rebuttable beyond that point. You then go to the planning balance and say, well, all things considered and taking account of the presumption, should there be a planning commission? That may be where we differ.
Thank you, sir. I just wanted to add that on page 2, in terms of the status, just to highlight and further muddy the waters, it is non-statutory Scottish planning policy. So as we work our way down these documents, it's worth pointing that out.
For completeness, Mr. Bell, what do you think that tells us, if anything, as to the weight it should be given?
I think factually that's correct, but as practitioners we know SPP is the national planning policy. It's an important material consideration. I don't think certainly in my view, whether it's statutory or not, doesn't give it any particular lesser standing in the inquiry today.
Is it the council's position that we should, because it's non-statutory, it should give it some lower status than if it had been?
I think so, yes. I mean, at the end of the day, the following paragraph, in paragraph 3 on page 2, states that the Planning Act requires planning applications to be determined in accordance with the development plan. It doesn't say they should be determined in accordance with the statutory or non-statutory Scottish planning policy.
No, this isn't a planning application.
The exact point, it falls as a material consideration in the case in the same way as the development plan.
Anything else on SPP before we move on, Mr. Bell? Okay, we're now finally getting to the development plan, 2015 LDP, if I can find it. In fact, I might not need to dig it out because I think Mr. Bell included extracts of the policies in his statement. Thank you. Although don't let that stop anyone else bringing other policies in if they think he's missed any. Sorry, my computer's gone to sleep. Right, sorry, finally got it working. So we have policy ER1 of the plan, renewable energy proposals, which offers support to all renewable energy proposals subject to certain criteria, and there's a series that apply to all such proposals, and then the policy goes on to more detailed matters in relation to onshore wind, which clearly are relevant here. And I think Mr. Bell highlighted earlier that he agrees with the bullet point 3 towards the top of the criterion 3, perhaps the top of the policy, and the use of the word unacceptable significant adverse impacts. So there's that, the fact that something is significant is not in itself fatal in terms of that policy analysis. Although I think I did spot later on the absence of the word unacceptable on a couple of occasions in respect of onshore wind. There's talk about significant effects as opposed to unacceptable significant effects. I'm not sure, I think I suspect there's nothing really in that. It's just it's phraseology. For example, top of page 23, the landscape is capable of accommodating development without significant detrimental impact on landscape character or visual amenity. I don't think it's the council's case that significant effect on landscape character or visual amenity would in itself be contrary to that criterion, given that that falls below an earlier use of the word unacceptable, am I right in thinking that you accept that there's an assessment of whether something is acceptable or not, rather than automatically a significant effect must equate to conflict with the policy? Is that right?
Yeah, I think that's fair enough. I think any lack of consistency is essentially the wording we were given from the examination from the LDP. So we've had to introduce that word. It's actually something we did pick up on in the new plan.
I think Mr. Bell's approach essentially was the key policy really is ER1. There are other policies referred to in the Council's objections, but that insofar as they are relevant to the assessment of this form of proposal, the matters are already requirements of ER1. I think, I'm not sure if that's, I'm not trying to ignore those other policies, but I think your point, Mr. Bell, was that you can actually use ER1 to assess the proposal to the full extent that is relevant to this type of proposal. Given that some of the other policies, ED7 was one that sprung to mind, has a number of criteria that probably don't really apply to this type of proposal. Is that right, Mr. Bell?
Yes, that's correct. The start of the policy, where there's reference to avoiding or addressing any unacceptable significant adverse impacts, then lists several criterion from landscape and visual impacts, noise, through to traffic and ecology, tourism and recreation. So, in my view, all the relevant aspects for development management purposes were captured by the scope of the policy, which underlines its lead status, if I can call it that, in the assessment. That's not to say that the other policies aren't relevant to take into account for a comprehensive policy assessment, but this ER1 is a helpful catch-all policy, if you like, in that regard.
Does the Council agree with that?
We're just obviously in terms of the committee report, which Mr McPherson's the author of, and in terms of hearing statement, we obviously identify that policies PP1, ED7, ER1 and IMP1 were quite important in terms of decision making for the reaching objection.
Maybe if we just look down at those again, I'm cheating by looking Mr. Bell's statement as he sets them out. So PP1 is in his statement under 3.5. This is PP1 Sustainable Economic Growth, page 31. Local development plan identifies employment land designations to support requirements identified in the Murray Economic Strategy. Well, that doesn't seem to help us a great deal here. Development proposals which support the strategy and will contribute towards delivery of sustainable economic growth and the transition of Murray towards a low-carbon economy will be supported where the quality of natural and built environment is safeguarded and the relevant policy and site requirements made. Is it your position that the relevant bits of that policy, or the most relevant bits, are, as you say, the failure to protect the natural and built environment?
That's correct. As set out in the report to committee, it's that balancing act again. We felt the second part wasn't met.
I think, Mr. Bell, you say PP1 only applies to developments envisaged in the Murray Economic Strategy. Oh, no, you don't, beg your pardon. You say as well as those developments that also contribute towards sustainable economic growth, which I assume that you think this does. So you accept that it applies and that it requires a balance?
Yes, that's right.
Next policy, I think Council referred to, is IMP1, which is on the same page a bit further down. Developer requirements. Development required to be sensitively sited, designed and serviced appropriate to the amenity of the surrounding area. And I guess this is obviously a general policy that would apply to all developments, and I think the council will accept some matters in there are probably not so relevant to this proposal, but I guess your point is it applies across the board, so you needed to apply it.
That's right, it's a catch-all policy, which is commonly applied, and obviously very similar to other policy approaches where we feel it doesn't meet all the criteria, particularly those first criteria.
Okay, I don't need to, I mean, I can work through the policy. It just struck me that criterion B, requirement that developments be integrated into surrounding landscape. We probably don't need to rehearse the argument as to whether that's ever a reasonable expectation of a wind energy development. Unless Mr. Bell specifically wants to say something about that. I think I know where you both stand. The policy applies to all proposals to the extent that it can be applied. I think is probably the issue. And then ED7, which is on 32. Again, this was the one that just struck me as an example of one where some of its intended focus appeared to be elsewhere. It talks about rural retailing and things like that, and presumption in favour of putting rural businesses into designated land rather than other places, if there is capacity elsewhere, all that sort of thing. Can you just explain why you think this is relevant to this sort of proposal?
Yes, it's a policy we apply to. I think you're quite right in saying it's a policy that can be applied to whisky distilleries, these sort of developments, and a wide range of rural developments. And it's really intended to find that balance between proactively supporting rural development and safeguarding the environment, which is set out in criteria D. The Safeguarding Balancing Act, if you like.
So just to emphasise, my view is it's of no useful relevance, and the only engagement it would seem to be would be if the council takes the view that this is an industrial activity. From reading, because it's not a new business development, it's not an extension to an industrial activity. It's really difficult to understand why that policy is engaged.
Are we saying that the operation of a wind farm is not an industrial activity?
When one looks at the policy wording in terms of emissions, adjacency to settlements, industrial estates, it's my reasonable reading of that, but it's not to do with commercial renewable wind energy development.
I think we take a different view where it is mentioned to an existing operation. I think the justification...
But it doesn't say that.
Sorry, I was talking. If you can let me finish. Thank you. In the justification, it talks about the council's desire to wish to support economic development in the countryside, sustain employment in rural areas, and that's one of the reasons we've included this policy.
Yeah, I understand. I mean, logically, you must see this as an extension to existing industrial economic activity in the countryside on that basis. Yeah, that's what... I'm not sure if it matters either way, but I understand that's why you think it applies. I think, Mr. Bell, you're saying you question whether it's reasonable to categorise this as an industrial economic activity, but if that, yeah, okay. And I think Mr. Campbell's view is, of course it is.
Well, as Mr. Kelly said memorably on another occasion, it's not a field of wheat. I'm sorry, but What is it if it's not industrial?
I think if when one looks at the spatial planning guidance within this policy, if one is going to use that to refuse wind farm developments, then it's quite clear that the spatial guidance in it is talking about adjacency to settlements, emissions, and the reference to industrial estate, suitable locations. None of that engages with the required siting for wind energy development. And I think the points in it, where I've got sympathy in it, is that the points in it that are relevant are already picked up within the scope of ER1. So my view would be ER1 is sufficient and has enough force to deal with the points that the Council was concerned with, rather than taking a view that this is an industrial activity and should be held back because of industrial spatial planning guidance that seems to be in this policy.
And it's probably fair to say the Council isn't holding those matters against you. It is just focusing on criteria on D. But I hear what you say. It strikes me as, yeah, it's perhaps stretching it to cover something like this, given the spatial element of where it would direct, or try to direct development to. You don't really want these sited on a industrial land in a village, for example. But anyway, I understand why you've applied it. I didn't have any specific queries other than that on the LDP, Mr. Bell, yet.
That there's 5 bullet points there. The position of the Council seems to be that the applicant has failed to take on board all the guidance. Secondly, that the guidelines have not been adhered to. Thirdly, that the proposal is a departure from landscape requirements. Fourthly, the proposal fails to comply with the guidance. And fifthly, the scale of the proposal is not in accordance with the guidance. So the issue I've got is the approach to applying the guidance seems, from that language used, to have been applied in the way that it would be development plan, section 25 approach. You don't comply with the policy, whereas when we go to ER1, it's a matter of addressing guidance. And I think that is an important distinction in terms of how the capacity study is applied and used, and to recognise that before we get into the detail of it.
I had intended to raise that point because you'd raised it earlier in the week. So the suggestion is that the evidence from the report handling is that your approach to the guidance and what is set out in the landscape capacity study has been to treat that as a sort of decision-making template almost, and that if it's the wrong side of a line or if it's too high, or if it doesn't accord precisely with what's set out in that, it doesn't tick the box. Is that fair?
No, the guidance, I think we're quite openly acknowledged in various documentation that is strategic level guidance, and that has to be interpreted by our landscape advisor, which has been the subject of much debate earlier in this week. So the guidance is part of the development plan, it's part of the statutory development plan. It is a framework, it's guidance, and we interpret that on a case-by-case basis through our appointed landscape advisor.
Can maybe add to that, just taking the report, the whole, certainly errors in the parlance, apologies, but taking that recommendation before having the whole, be very careful at the outset of the observation section to highlight the role of the plan and guidance in terms of being a Section 36 process. Obviously, this is a report to members, a planning committee. So, and the observations, which is about page 5 or 6 into the report, I'm very careful to set out the role that our legislation, our guidance has in terms of this being a Section 36 process, and obviously then go on to make sure we set out the framework for national guidance before going down towards a local development plan. So, certainly in terms of the flow of the report, it's made very clear to elected members in considering this that we are talking about the status of the local development plan and the guidance as being different to that had been a Section 25 application.
I fully accept that acknowledgements correctly in the start of your report, but on page 16 of the report of handling, it says the proposals failed to take on board all the guidance for LCT 11. Neither guideline appears to have been adhered to, and so on. All that language I've just referred to is in one paragraph, and I would just leave it with the position that if that's set out in that way, then I would say it's of little surprise that members would go with that clear position of not adhering to, not complying with, and failing to take on board. It comes across to me as very strong and not in line with what actually ER1 actually says in terms of the use of the capacity study.
Ultimately, that informs the language was to inform whether or not the applicant has taken into consideration supplementary guidance that informs ER1. I'll draw your attention to the conclusions of the report, just to the sort of third last page of the report of handling. And we then try to pull members back to bear in mind some of the issues that were raised already about the national targets, the national guidance, and our recommendations. So we do try and put it in this context towards the end of the report.
Okay, I understand. Probably now a good time to actually look at the supplementary guidance and the capacity study. The discussion we've had over the course of the week has been helpful to me in understanding what both of those documents say, what they expect, what the attached plans show in relation to the location of this site. As I understand it, the Council's position is the supplementary guidance is part of the development plan. I don't think you're saying that the landscape capacity study is part of the development plan, but you're saying it's a material consideration. Is that right?
That's correct, although it's perhaps a little bit unclear as well, because on page 11, let's find the reference. On page 11, the top paragraph ends saying landscape capacity study update, which has been included as an appendix to supplementary guidance and will therefore form part of the statutory local development plan.
I hadn't spotted that, but I mean I know that's a stance taken by other authorities that have attached something onto a supplementary guidance which is attached onto a plan. I have no idea whether that's right in law or not. Fortunately, we're not in a planning application here, so it probably doesn't matter that much. They're all material considerations, but that's helpful. I hadn't spotted that point. So as I say, I'm fairly confident I understand what the various documents are saying, so it's probably perhaps quicker simply to ask for party submissions as to what they think about these two documents and the importance to my recommendation. I'll turn first to or for the council, the applicant side.
Thanks, sir. Yes, because of various noises, I didn't quite hear what council said. Is it confirmed it's not part of the development plan, the LCS?
I think we've added to the confusion by pointing out on page 11. It suggests that the appendix is an appendix to supplementary guidance and will therefore form part of the statutory local development plan.
I'm not sure that it is, but this is the same problem as arisen in the Scottish Borders, where the supplementary guidance of recent date places emphasis in its text on the landscape capacity study and says that it will be determinative or assist in the determination. So it's very much the same sort of language. I suppose that technically, is it part of the development plan? It can only be part of the development plan if it's adopted by the council as such, and the document hasn't been. So,
well, it's a precise question, and it varies from area to area. Across Scotland, some LCS is part of the development plan, some are not. My question is simply, is it? If the supplementary guidance says it is, I suppose we have to accept it is, and the report is right, it may not matter that much. But what's the basis for saying it is? Is there some minute of the council which, or letter from the Scottish ministers which confirms that?
Well, the supplementary guidance has been approved by the Scottish Government, and as I've just read out from page 11, it clearly suggests that the landscape capacity study is forming part of the statutory local development plan.
I'll have to
as
take
approved
that
by
face
the council.
value in the absence of anything else. It doesn't matter that much. I'll take that answer. That's fine. So far as the SG is concerned, as I told some point in the inquiry session, and that's why I'm doing this. I trawled some points in the inquiry session with Carol Anderson and said, putting down markers and to respond to the point. I said that I would want to follow them through now, so now's the time. The LDS for open roading uplands within which we are, paragraph 17.3, page 77, that some very limited scope has been identified. Very large turbines, that is 130 to 150 metres. It actually says around 150 metres high within this landscape. And Caroline has confirmed that meant not just extensions or repowering, but new development. So that's what the LCS says. It also talks about repowering in a special section and envisages for LCT 11, within which we sit, that there will be, turn to the right page, paragraph 44, page 25, scope for up to 150 metres for repowering of Paul's Hill wind farm in the open upland. So we have that, and then we come on to the SG, which appears to me to say somewhat different, something different. This we need clarification from the council on map 1 for the SG. There is a pink notation, caption, whatever. It says areas of greatest potential large. Map 1. Areas of greatest potential large. And I explored this with Carol Anderson, and we agreed that large meant large typology and not very large. And obviously we couldn't agree. It's up to the council to tell us now if that means that there is no identified capacity for very large turbines other than extensions and repowering within Murray. That's a question. I think we need a clear answer on that. So far as repowerings and extensions are concerned, the position is clearer looking at map 4. In the area around Paul's Hill, I'm not going to start to define precise boundaries. That's not the point of the exercise now. It's area 2, looking at the right of the page, up to 150 metres. in that area for extensions and repowering. So that's clear enough. But we do need an answer on the... People are making a habit of going in and out constantly. But on new sites, we need some clarity here. The other points just to make on the SG are looking, well, sorry, following on that point, page 20 of the SG. On second paragraph, turbine same size, same scales, same operational speed for extensions. Yet on map 4 rather, we have allowance for up to 150 metres for extensions. So again, there's an inconsistency there, a very G, since all the existing wind farms that might be extended are nowhere near 150 metres. So I think we need some clarification of what the Council intends in the SG so far as that's concerned. A separate topic at Landmark Hills. I explored this with Carol Anderson. We know there are a creation of the 2012 landscape capacity study rolled forward into 2017. We know there's no LDP policy. What we have in the SG is a page 74 glossary and some advice on map 7, and that's all we have. I'd welcome a discussion about the appropriateness of a mapped feature being given planning weight in this sort of way, given that it's been this map feature has been identified not simply as a mapped feature in Murray, mapped feature of Murray for its own sake, but simply in the context of wind energy development. Seems to us a bit pointed. Coming back to page 12 of the SG, I've already made earlier points about the inappropriateness of taking account of these issues at a development planning as opposed to management stage. I'll leave that there. But I do note that even with this more refined exercise, with a lot more buffers taken into account, nevertheless, the area around Paul's Hill, in fact Paul's Hill 2, if you want to draw fine boundaries, try, but on the basis of that hatching, we are favoured for an extension up to 150 metres. So we pass even the inappropriately stringent tests of the SPP 162 exercise. I don't think I have any more to say about the LCS. It's all been done as far as I'm concerned, sir. Thank you.
Quite a lot of different points there. I don't know if you got them all. If not, I'm sure we can reiterate them in whichever order you like.
I'll certainly try. Can I start off by just, because I obviously see where I'm being led, but in terms of the areas of greatest potential, just the definition of them, just to make it quite clear that that definition set out on page 13 of the wind energy guidance. It doesn't mean it's a green light. It means that areas of greatest potential are areas of greatest scope for further investigating the feasibility of developing wind farms. I think that's a very important point. To try and pick up and remember Mr. Trinick's points, I think the first one was asking about the sort of reddy pink colour, the area's greatest potential large, and I think Mr. Trinick was asking, is the scope for up to 150 metre high turbines restricted to only the areas identified for extensions and repowering? And you're suggesting there's maybe inconsistency between the guidance and the LCS. I think that could have been clearer with hindsight, and yes, it is intended to be within the area for extension and repowering. On a similar theme, again with hindsight, perhaps it would have been easier if we'd clarified which areas we thought there was scope for extension and which areas we thought there was scope for repowering. I think the comment about the guidance in terms of extensions having to be of a similar scale, type of turbine and such like, I think that was debated with Carol Anderson. I think we're quite clear what Carol's view on that is, and that's the Council's view, is that extension should be consistent with the existing operational wind farm. I think Paul's Hill is deemed to be a fairly well-designed wind farm, sits well within the landscape, minimises impacts. and we'd wish to see any extension carrying on that design iteration. And our view is that the current proposal doesn't do that for the reasons explained in the committee report and the reasons for rejection. I think the next point was about landmark hills. I think that would be a more appropriate discussion if Carol was here and present, as Carol was the author of the co-author of the original guidance which identified these hills. So I'm not quite sure how far we can debate that today. That's as far as my notes went. I may have missed the last point, Mr. Trinity.
Can you clarify one thing? I'm not sure I still understand it. On map 1, my very precise question is, does this map simply identify through pink areas of potential? I know it's potential, you've got to look at the detail, for up to 130 or up to 150? Which?
Up to 130. My apologies. I thought I was quite precise in saying that the areas with greatest potential for up to very large typologies to 150 metres are within the areas, the hatched areas, potential development areas for extensions and repowering.
On the question of the landmark hills and how they found, or how they were identified, my note was, and I thought you might be able to have a view as to, there doesn't appear to be an LDP policy specifically to sort of hang that on, or is there? There's no reference in the LDP, I think Mr. Trinity is saying, to landmark hills. They were a creation of something else, the LCS. I think his question is, what do you think about it? Are you content that, I'm presuming that was you were content that they appeared in the LCS, notwithstanding the fact that there was no sort of foreshadowing in the LDP itself?
Yeah, you're right. There's no policy about landmark hills in the LDP. The landmark hills came out of that first version of the wind energy guidance, which Carol and Alison Grant worked on and prepared for us, and they've been carried forward into the existing guidance. They're key landmark hills, key features of the landscape for the reasons outlined in the guidance.
On the question of, I hear what you say, the expectation that extensions to wind farms should be consistent with existing, but do you accept that submarine guidance does use slightly more strict requirements than just consistent? Proposed extensions should incorporate perhaps same design principles. Okay, I can say that requires consistency, but same size, same scale, same colour, same rotational speed. They're not just consistent, they are the same. Is that perhaps slightly stricter language?
Yeah, sorry, that statement's carried forward from guidance from our landscape advisor and from SNH. So in terms of dealing with extensions, we want them to look essentially like an extension to the existing wind farm and keep that consistency.
Do you want to come back on anything? Anything else to say on either of the two documents, supplementary guidance or the capacity study?
Just a general point. I know the point was made in the past few days to our landscape advisor about practicalities of us looking for turbines of a similar scale and scope. I think it's a general point. We had some criticism about the fact that our guidance on page 12 tries to basically drill down, giving more practical advice on buffers and other constraints. I know that Mr. Trinnick talked about there should really be a development management unit. I think just in general terms, trying to basically council charged with giving supplementary guidance, which is actually meaningful. If it's meaningful to, if there's criticism of producing turbines of a similar size and extension is criticised given constraints of technical design, in the same way national guidance that we see in SVP, where Mr. Timmelson referred to 50% of money being covered. I think it's similarly practical reasonable for the council to have basically given advice that tries not to have turbines in back gardens, domestic buffers, etc. So the general point just about if we can apply a reasonable test to turbines have evolved in the same spirit of what's reasonable, what's sensible, that's given guidance about beyond the government's guidance and SVP about what's practically possible to direct developers to. It should be equal relevance.
Can we move on, if we need to the proposed plan? Now we've heard, hopefully, it should be coming back from its examination early in the new year, and all going well. I think I'm right in saying that the applicant has objected to elements of that, and as a consequence of that, the council at this stage is not giving it any weight, I think, on the basis that it could be subject to modifications or recommendations of modifications from reporters. Can you just explain, Mr. Bell, in what regard you're objecting to the proposed plan?
CD 4.9 sets out the letter of objection. I would need to go to it, actually, to just refresh on the points raised, because they're quite detailed. But in effect, it seeks to just bring the policy approach more in line with government policy and guidance. And I think it will need to be looked at again in terms of the new targets, probably, and matters we discussed this morning. So happy to delve into that letter, but to give you some more detail on it. But it goes into a fairly fine-grained analysis of the policy wording, the draft policy wording, and suggested changes.
Yeah, I see that. I confess I hadn't read that. I was just aware, I was being lazy, I was aware that you had lodged an objection to it, and I left it at that. Now I realise just how long and detailed the points are. I'm not necessarily convinced it would be a good use of our time to go into that in massive detail, unless you desperately want to, or indeed the council desperately wants to. I'm happy to read what you say. I don't know if the council wants to say, because I don't think I have before anything Schedule 4 in respect of that matter in the
highlight, and it's one of the key points was the council's approach seems to be to incorporate selected landscape capacity maps from the LCS into the LDP. I think that's right, and I was setting out the approach that wouldn't be appropriate, and I gave reasoning as to why that would be the case, and just seen it with the report of examination out for Dumfries and Galloway, where the reporter decided that would give undue prominence to the landscape capacity exercise, and they were taken out of the proposed LDP2 in Dumfries and Galloway. So it's that kind of thing that been suggesting, as well as references to the policy wording, and it's intended to be a positive contribution to the plan in terms of making it sound and fit for getting through examination.
Thank you. Just to be fair to the applicant, I think we've got a copy of the Schedule 4 here as well, so we'll provide that to you, sir. To be fair to the applicant, I think one of the issues was that we'd missed out, which didn't come from your objection, but it's public information, that we missed out the mapping around extensions and repowering, and our Schedule 4 sets out that was simply an error on our behalf, and we've offered to rectify that through the Schedule 4.
for the benefit of the recording, unless the applicant has any major problems, I was minded to accept the offer of a copy of the Schedule 4, just so obviously I've already got this applicant's objections. There may be other objections to the policy, and also I can see what the council's intended response, or what its response was. Just in terms of timing, I'm pretty confident that my recommendation to ministers will be out before the plan, but of course ministers' decisions are unlikely to be out before the new plan. I need to be able to advise them what I think about the emerging plan, and they need to have some guidance on it. So I think it would just help my understanding if I had that before me, unless anyone desperately disagrees with that. If you've got a copy, that'd be great to hand it. Excellent, thank you. Anything else on the policy matters? Mr. Trinnick.
It's semi on the policy matter. It's my only opportunity to raise this matter, so I'm going to. Save Wild Murray. We have an email, you have an email from Ian Kelly of 11 March 2019 saying he's just been appointed by Mr. Mark Holdsworth, an objector. Mr. Mark Holdsworth, in the process, setting up an unincorporated grouping of objectors to be known as Save Wild Murray. He wants to participate in the inquiry with the evidence being led in the name of Save Wild Murray. Then we have the policy hearing statement submitted by Mr. Kelly. Save Wild Murray described paragraph 1, unincorporated grouping of locally based objectors. We were curious as to who these people were, so we went on to their website, which is extensive, and which contains what I can only describe as some fairly vitriolic wording about those behind Paul's Hill 2 and the process of going to inquiry on Paul's Hill 2. For example, the Scottish Government's machinery grinds on in its attempt to override local democracy, showing utter contempt for the clear views of regional representatives. Quangos being consulted, hopelessly compromised either through dependency on their political playmasters. The whole entire process polluted from top to bottom. Well, I don't think what they want, but what I'd like to know from Mr. Kelly, and I'd like a clear answer, is how many people have subscribed to the views of Save Wild Murray such that he can say that he represents them at this inquiry. Noting that despite the website indicating an evening session, there are insufficient numbers to warrant that evening session.
I don't know the number of members, current members, but that can be found out and circulated. In terms of the group's website, which is similar to many other websites I've seen, I do not present their website as evidence to this inquiry. They have sought my advice as a group. I have given my advice to the group as to the appropriate participation in this inquiry. That advice has been heeded, and that then forms the evidence led to this inquiry. I did not present anything from the website as an inquiry or hearing document, and quite deliberately focused on the areas that I have focused on. But as I say, sir, in terms of the numbers, that can be identified and circulated for parties to comment on as they wish.
Well, so that's a remarkable statement at the end of the first week of a public inquiry that Mr. Kelly doesn't know how many people he represents. We know he represents Mr. Holdsworth. I don't know that he represents anyone other than Mr. Holdsworth. I fully accept there may be others who subscribe to Save Wild Murray, but I think you, in reporting to the ministers, at least in my view, need to know roughly the level of support that Save Wild Murray enjoys, roughly the number of people who have subscribed. I don't mean lots of the people have objected and they must all therefore support Save Wild Murray. I mean people who've been in touch with Mr. Kelly or Mr. Holdsworth and said, yes, count us in as part of Save Wild Murray. and I'm surprised that Mr. Kelly doesn't have the information. Yes, we would like it.
Okay, well, he's kindly offered to provide that. If you could do that in writing within, say, a week, that would be much appreciated. Thank you.
Absolutely. Absolutely.
Anything else on policy? I'll go around. Mr. Kelly, anything else you wanted to say? No?
No, thank you, sir.
I have a question of Mr. Bell, if I may ask it through you. It's in relation to his inquiry report. I beg your pardon, hearing statement. Page 36, paragraph 4.1.2. There's 36. There's a name in the fourth line, which I suspect may be a name from another inquiry, and that would betray that this paragraph has been imported. That's a perfectly fair technique. But just in case I'm wrong, is this gentleman anything to do with this case?
Anything from anybody else on policy? No? Nope. Okay, thank you all very much. Sorry that was, as it always is, a bit of an ordeal, particularly for those who aren't professionally interested in such matters. I'm sorry if that was fairly boring to endure, but it is important and necessary. Now, I think we do need a break before we move on to things that might be of more interest to the local people, which is socio-economic effects. It's 5 minutes to 1. Can we get away with half an hour for lunch? Yes, Mr. Campbell? Yeah, we're happy. So, well, I'll be generous and we'll say 1:30, 35 minutes, and we'll get on to socio-economic effects. Thank you. Thank you. I think we're all here. So, socio-economic effects.
So for those that are interested, Australia 245 for 5.
I can't stand cricket, so. Right. Socioeconomic effects. I think we all know, there's no new faces, we all know who we are. The point of the session is so that I can advise ministers on the evidence of both positive and negative effects, so that they can weigh those in the balance, along with any other effects. But obviously today we're interested in socio-economic effects. I circulated an agenda where I identified certain matters that I wanted to talk about, the first of which was Visit Scotland's request for a tourism impact statement, and I then wanted to go on to ask the parties what evidence there is for positive effects and then for negative effects. The rest of the agenda I think we will deal with amongst that discussion. I don't think we necessarily need to have separate agenda points. The latter 2 points in the agenda were, well, what should we draw from that balance? I'm not sure we'll actually get any agreement on that point as to whether the net effect is positive or negative, because I don't think we'll get any agreement there. And the question of do we have actually sufficient data to make an assessment, I think is likely to be discussed as we go along. And in fact, that kind of leads me back to the first point on the agenda, which is Visit Scotland's request, or requests, because I think they issued a very similar, if not identical, letter in response to the additional information as they did last year in response to the application, which is CD 229, I think. And what struck me about that letter is clearly they have a role to promote tourism in Scotland, and they stress the importance of scenery to tourism, and how scenery in the natural environment are two of the most important factors to anyone when choosing a holiday location. And they explain some of the research that has been done into visitor experience surveys and things, and the importance that visitors to Scotland place on the landscape, etc. They also interestingly refer to research that's been done on the effects of wind energy, if any, on visitor numbers and things at a sort of broad level, which Mr. Bell may refer me to. But the conclusion is, as it often is in this type of proposal, is they want a tourism impact assessment. They don't exactly specify what form that should take, and that's kind of my question, as do we have that with this proposal? If not, is that a problem? Do we, notwithstanding the absence of that, if that's the case, do we still have sufficient information for ministers to make a judgment? What do the parties think Visit Scotland is expecting from a tourism impact assessment? Is it an assessment of individual properties that might be affected, individual businesses, or is it a more high-level study of the evidence base for, or what evidence there is to support the fears of tourism operators that this type of development is likely to have an adverse effect? I turn first to the applicant.
Thank you. Sir, I would say that the Visit Scotland request is fairly standard. We see that request reference to Scotland's landscape and scenery and the need for tourism impact assessment in standard consultation responses. And the supporting EIA report with the application contains Chapter 13, Human Health and Population. That's the new terminology in light of the updated EIA regulations. And that addresses tourism and recreation as part of the socio-economic context assessment. So the applicant has undertaken an assessment drawing upon available research. It's done at that level rather than going into individual business assessments, which is not my understanding of what the Visit Scotland standard response is seeking.
And I think I'm right in saying they haven't, indeed I don't think they ever do object. They just say, take it into account. And you say that you have. You say you've done what they expect.
Yes, that's right. The Council found that satisfactory. That is standard practice in terms of impact assessments being undertaken as part of the overall EIA process.
Does anyone, it's hard when Visit Scotland aren't here, but does anyone disagree with whether what the applicant has done is sufficient to satisfy Visit Scotland's expectation for a tourism impact assessment? Mr. Ponzio.
The EIA report did take into account the Spey Valley AGLV area, the Speyside Way, the Davil Way, the tourist routes within Murray, core paths, Ballindalloch Castle, as well as different types of walking and cycling routes and so on. And Mr. Bonzio is right, there is data available. It's the CD 12.8 document, Murray Facts and Figures, straight off the Murray Council website. And it's got a very helpful section on tourism. And it states that tourism is important in Murray, 10% of Murray's workforce, 3.8% of turnover of businesses. And since in 2017, there was a significant increase of £11 million on over 9.6% on the previous year. Visitor numbers increased 7.4%, and it adds that since 2009, an extra 177,000 people have visited the area, and an additional £92 million spending in tourism. So the figures very much indicate that this is not a fragile sector of the economy. It's one that is robust, is rising in terms of its economic value. Importantly, I think, to recognise that it's coexisting successfully with a growing renewable energy industry. And that is not just, I would say, common to Murray, but is characteristic in broader Scotland, in other areas where aspects of the tourism economy are important, such as in Caithness, for example, and we see quite significant further deployment of onshore wind. I think that's absolutely right. And I think if I picked you up correctly, Mr. Bonzio, you were saying about 60% of your guests are connected with the whisky industry. And I would see that as it's very good that you've got that. And because the whisky industry is so strong in Murray, it's such a driver and attractor. And Macallan's investment, I don't know, sir, if you've been to the Macallan Visitor Centre, it's certainly worthwhile. It's not far. And I think it's £70 million invested in that centre. It's fantastic environment and quality. It will be an international draw, I'm sure of that. Where you get, in my experience, where you get very strong draws like that are unique. You can't go anywhere else because it's Speyside. You will still get that people coming for that draw, and would not, in my view, be put off an initial or a repeat visit because they might see a wind turbine. So I would suggest that the customer base that you've got, the very foundation that you've got of 60% connected to the industry, should be retained because their primary draw is whisky related, and that is such a strong draw factor within Murray.
just wondering, in connection with your point, Mr. Bell, about the Bonziers being fortunate that they can benefit from the unique attraction of their connection. They can benefit from their connection to the whisky industry, which has a unique attraction in this part of the world. But is it not the case that their existing whisky clients could, if they felt that their clients weren't happy with seeing the turbines, send them somewhere else, albeit in Speyside, but perhaps not down the road from your development, in which case the distillery would continue to be fine, but it would be somebody else who would benefit. Is that a problem? It's clearly a problem for the Bonziers if it were to happen, but what do you say to that?
I just jump in? Yeah. I just wanted to pose one situation, because I do agree that the distilleries coexist very well, but they're not being tested like we're tested, or are going to be tested if it's approved. If you were to say transport Rothes 3, or even Paul's Hill 2, and put that 1.5 kilometres from Distillery Visitor Centre at McAllen's, I don't know if the test would stand up under that situation, because then visitors may not enjoy the experience. They may be offended, in fact, that when they go to McAllen's, right there is a 700-foot turbine, especially when you say that the new way is taller turbines. So a lot of reference is past-based, whereas we have to look to the future. And so we're looking at 600 turbines in the future. That cannot be tested properly because it hasn't happened yet. So perhaps there isn't feedback that it bothered people. You right?
I think on McAllen, I think when I drove into the car park, correctly if I'm wrong, because you may know better, I did see Hill of Towie, I believe.
But not 1.5 kilometres from the front door.
No.
That's a completely different situation.
And I fully accept some people will think, oh my God, that is appalling, how could the landscape be affected like that? Other people might say, we do have a climate emergency.
Of course, I agree with that.
It's great to see Murray
but
as...
you're going to lose some people. You admit you're going to lose some people along the way.
People will take different views of that, I fully accept it. But in many ways now, the way the mood has changed with Extinction Rebellion, the school strikes, Greta Thunberg, all that, in affecting the sort of wider public opinion.
I think my point was more the test case being with the McAllen's and the distillery in general, not the public's reaction to it. So would they be happy today if you put planning permission in for say 44 turbines, the closest being 1.45 kilometres from the place? Yeah. And I don't know the answer to that. Maybe they wouldn't, but it's a question.
Yeah. I think, and quite understandably so, there are a number of proposals in the planning system in Murray at the moment. I think what we're dealing with is a fairly modest extension to a wind farm, and I appreciate, of course, you're local to it, and that's a different dimension. But there are the wider proposals in the area, and understandably, people were concerned about what might result if all those do occur. But I don't have an answer to that because we're not dealing with those schemes at this inquiry. Yeah. And what we do have in the EIA report is the weight of evidence that's been examined in the Committee on Energy Tourism in the Scottish Parliament, various academics, various economists well respected in Scotland, and other EIA reports from elsewhere in Scotland. So as a planner, I need to understand those findings and take them into account. And having read that and being familiar with that weight of reporting from elsewhere in Scotland, I'm quite confident that those broad conclusions are correct. And I haven't seen evidence that there are significant detrimental impacts on local businesses Well,
and then you talk about planning balance and sustainability, but I mean, where do we fit in your planning balance?
okay.
You know, sorry, apologies.
What I would say is that in terms of the local situation, I've taken the view from Mr. Denny, who's undertaken an assessment in terms of the amenity effects of the turbines. And we've got the situation, of course, with T1 that's been referred to in terms of whether it is in the consented scheme or not. And the view is that the effects are acceptable. And that is the local position in terms of the effect of the proposal to extension.
These effects depend on the statement of Mr. Denny. But I heard a lot today this one planning balance, and that was the second question. You know, where do we fit in? Everything is on that planning balance of your proposal, but local businesses, and this is acceptable that small businesses taking an unacceptable risk by the development, but where is this balance? Where do we fit into that balance?
Some significant effects have been identified. We started off with talking about facts. That doesn't necessarily translate through to the fact that businesses would be damaged by those effects. So the weight of evidence, we've set that out quite carefully in the EIA report and in the policy hearing statement, points to there being no evidence from anywhere in Scotland that there are such effects arising. It points the other way. And when that is combined with the local amenity effects that Mr. Denny has identified, that leads up to the overall balance factor, that there's the public interest and the benefits that flow from this development, and taking into account the evidence that there is in terms of tourism and recreation and impact in that sector. So it's the interplay of all of those factors together.
So basically we are having to accept the risk that one business puts another business out of business, basically. Because we have the holiday cottage, which is entirely on its tranquility, the land value, and we made a survey, a quite neutral survey, and 90% of our clients today, and we have clients who come back 10 years repeatedly, and we are the closest neighbor to the provider. And we have full polarized evidence, and they tell them the reason why they are coming to us, and also whether they would rebook, whether they will recommend, and over 90% that they would not come back, they would not recommend. And so we have evidence, no matter what Mr. Denny said, that is acceptable. Again, Moray Council is big, and also space-side. We are talking potentially just a few businesses, 4 businesses in the Arder Valley. And we are the closest neighbors to you.
Would you say, Mr. Bell, it's fair to say that clearly ministers need to make a decision based on evidence, and the evidence that has been commissioned over the years on a few occasions, as you say, all points towards the understandable fears of an adverse impact not being supported by evidence of actual harm. However, is it fair to say that they were generally quite broad-ranging surveys, so the effect at a Murray-wide level, or perhaps smaller than that, but not, for example, the effect on a particular valley, so that the absence of evidence of harm, you can't necessarily conclude from those surveys as being reassuring to the Bonzios. It may point to perhaps some fear that turns out not to be realised, because that is the picture that appears to be more widely, but perhaps that's because it didn't look close enough at the very localised effect. Is that fair?
could I just, sorry, could I just, that saying that people come first for the room, I agree they maybe come 50-50, but when nearly every booking I get, the first thing they say to me is, we love what you're showing. They're reading our reviews. Every review mentions, I would say 90% mentions landscape really high and in a really positive manner. So even if the landscape is secondary to the room, right now we have both values, right? So we're getting to draw on both. So I keep hearing this argument, because you have one, it's okay you lose the other. It's like for Bonzio's you saying, well, it's kind of okay for you to lose your landscape value to your outdoor activities or your customers because, well, you can draw from the whiskey industry, which they do. But their potential prior to the wind farm was to draw from both. So obviously it's going to decrease if you start diminishing the quality of one of those aspects. That would be my argument to that. And I just wanted to touch quickly on Mr. Denny. As you say, and I believe and I understand, energy is going to grow. It's going to become more and more. It's going to be taller turbines, et cetera, et cetera. But maybe in that instance, could it not be that in the pre-production, the pre-planning, in the prior to assessments, that because you argue you want to be taken case by case, there's only two of us. Case by case could have mean that prior to assessments, someone actually talked to us. Because individually, we have really, really different needs from our land. Even we do, but say someone 2 kilometers away may not have the same expectation from their property or want to use the same resources. So if someone took time to get to know us, each person would be very individual. And I'm not saying the impact would be less or more, but there is a chance it could be different. And we weren't given that opportunity. We're given an opportunity to talk now, which I really appreciate, but we're behind the ball because we have to fight the conclusions that were reached, which impact us probably more than anybody else, but we were not part of the dialogue in those conclusions. So I think maybe this is, obviously can't change what happened, but going future, if it's going to be more and more people affected, which obviously it will be as renewable energy grows, then perhaps it should be a more respectful process to the residents that we're included even in the pre-planning. And in case of, if you're going to put a turbine 1.5 kilometers from someone's residence, then you kind of have to expect kickback, and it should be in the process, it should be in the planning, it should be in your budgets to deal with it. It should be just part of the process, which I feel like we have to now jump through hoops to protect ourselves.
Hopefully that, and I'm sure that representation and concern that was expressed to the Planning Authority in objections. The Planning Authority have chartered planners who've considered the balance of all the considerations, and they deemed it also that it wasn't a matter that would justify objecting to the application. It didn't come through in the reasons. But there is another opportunity now, and that's being aired, that these matters are being considered against the findings of the EIA report.
I think it's a big disadvantage when assessments have been made by experts. We don't have the resource of hiring a team to support our position. So once it's kind of like once the conclusion is made, it's very hard to change that mind. It's almost impossible. But if you're part of the dialogue that comes to the conclusion, then you're heard, and maybe the outcome will be the same, but at least you've contributed to that conclusion.
Denny's evidence, because Mr. Denny has not considered the cumulative effect. We moved to coal glass 23 years ago. We are opposing, or we opposed coal cell 1, so we are, since 2001, in this ever-continuing fight against developments in our small area. And we are just talking, there is no mitigation for coal cell 1. And we don't even talk about Glashgower and Rosses 3 coming in. And and or the repowering. So it's an ever vicious circle. I'm 61, probably for the rest of my life. I'm gonna do the same what we are doing today.
Hopefully not, Mr. Beldew, but I know what you're saying there. The cumulative picture has been examined by Mr. Denny in the landscape and visual impact assessment. But the merits or otherwise of those projects will be considered in due course under a different process. But in terms of mitigation, I just wanted to say that was the Knockando Cross location not an initiative that came out of Paul's Hill 1 that allowed you access to the land there for various activities?
The cottage was another part at the time. What happens this time? Nothing. And those turbines, those mitigations were dealt with during the construction period, whereas now we are facing a development which is there forever. And as much as you wish that it's not going to be for the end of my days, it will be. Because if we are talking of a lifespan of 25 years, repowering, so we are talking 50 years, so I'm not living to 110. So this mitigation you're talking about was in 2004, during the construction period. What happens now during the construction period? And what happened once the turbines are built and be affected? Because, as Mr. Denny said, the rear view of our cottage are affected. No, those are the main views, which are 90-degree or direct visualization onto that development. And the other window looking at Rosse 3 and Klashgawa. So where is the mitigation for that?
The construction period is relatively limited, but the Knockando Cross area, as I understand it, continues to be an area that you can use for your activities as well.
Correct. And what is with our cottage guest?
I've been to your property and I've seen the cottage, but there are also, it's not an only view, there are other views, are there not, from the cottage?
Yeah, from the bathroom. Yeah, you're right. From the bathroom and the toilet down the valley.
And indeed from outside the property.
From outside? No, from outside, wherever you go in the cottage. Maybe you haven't looked at the cottage properly.
I walked around it.
Yeah, so you see from every location around the cottage, not even when you walk out the front door, where I mentioned the toilet view, you're going to see Rosse 3. So your statement is incorrect that there are other views. You tell me which other views there are.
Well,
so onto the farm.
I don't know
yes,
if we can
correct.
say this much more in this forum.
Yeah, I think I just for the benefit of clarity, and I know the fear that residents have that were ministers to allow this, it would open the door to Rothestry and Flashgower. That's not by any means necessarily the case, and my advice to ministers is only about Paul's Hill 2. So as far as my report goes, it will be contemplating the potential cumulative effects in other scenarios, but the effect of ministers granting permission now in no way opens the door to the others. Some might argue it makes it harder for the others, to come forward, but none of that in a way matters. I'm interested in the effects of Paul's Hill 2 on you, and on that basis, I guess I had a question really for Mr. Bell. I know you're involved in a very large number of wind farm proposals. This, compared to some anyway, in terms of its relationship with 2 or 3, if you count 2 at Foreglass, tourism-related businesses, would you say that that's quite unusual in terms of the proximity in your experience of what's now proposed to businesses which I think everyone accepts, to some extent at least, rely upon the quality of their immediate landscape surroundings? Is that unusual?
There's certainly cases such as Drone Hill, which has it's in Scottish Borders, which is a caravan park, very, very close to it, and areas of Caithness, where there is extensive coverage of wind farms and indeed parts of Scottish borders. But it is fair to say that the position of the two properties is relatively close, but there are, as I say, situations elsewhere where there are tourism and recreational businesses relatively close by, and no evidence from those locations that there have been negative effects. And certainly at the inquiries I dealt with, certainly at Drone Hill, where there were fears of that, that has not resulted.
How do you know? I mean, the inquiry reporter may have found in your favour that their fears were unfounded, but has anyone actually gone back to say, were you right, were we right, did it actually turn out to be as bad as you feared? Has that actually ever been done?
Well, yes, the bigger economic study in 2017 did look at areas where there had been significant deployment and, again, no negative effects identified. And I think one of the points is that the issue does crop up regularly at inquiries and in hearings. And I think if there was evidence available, then it would be brought to light. We would see that, and simply have not seen it.
That was really my question for Mr. Campbell. If the wind farm developers had been wrong, and in fact it was as bad as operators of tourism businesses had feared, they would be coming to subsequent inquiries saying, "Don't believe them. It has been a disaster as we predicted." We've not seen that. Is that fair?
Not entirely, no. The planning process is not a user-friendly environment for lay people. I think those on both sides of me would agree with that. What we've seen, though, is that what we are talking about now is the difficulty of quantifying, probably in financial terms, the fear which is often, as Mr. Bell tells us, is often expressed at inquiries like this. Now, often cited in inquiries is the example of Cornwall, which has a number of wind farms, indeed some of the very early and smaller ones, and no shortage of tourists. My daughter's a doctor in Cornwall, and she hates the summer because you can't move for tourists. Mr. Trent comes from there, and you'll know what I'm talking about. It's rather different in Scotland because you have tourism operations of a small scale, such as those belonging to Mr. and Mrs. Bonzio, which rely for their success upon a key component. And so whilst we may not be talking about a loss of revenue in 2021 or 2022, the point that's made in the hearing statement from the Bonzios is that it is likely, because people have a choice and are all the time becoming more discriminating, it is likely, or indeed just possible perhaps, that those with that choice will choose to go elsewhere. Holidays are precious to people. It's more and more difficult to go abroad, not only because of Brexit, but because of the horror of the airports. And so holidays in Britain are becoming, I think, much more popular. Now, I know we're talking about a very small operation here, because it's only one holiday cottage and it's only one business, and Mrs. Mandel's business as well. But nevertheless, these businesses have sustained this couple and their family for nearly a quarter of a century in reliance upon the environment in which they are located. These criteria are all set out for you in, I forgot paragraph numbers, but it's page 5 onto 6 of the hearing statement. We don't need to repeat them just now. And what, in fact, we may be discussing is the relative fragility of businesses of that size, which do sustain people, but nevertheless are vulnerable to small changes which are beyond their control. What we're saying here, without overcomplicating it, is the key component for, sorry, I put this another way. The Bonzio situation is slightly different from the bed and breakfast owner who comes to a planning inquiry and says, we'll see a fall-off in tourists, because not only is Corglass their home, and you've heard all about the residential amenity issues, but it's also their workplace. And so everything depends on it. If you like, all the eggs are in this basket. And therefore, if we take the risk with Paul's Hill 2, that may, as you say, open the door to other development. You can't take that into account. It may make other development more difficult. You can't take that into account. But down the road, because you have to think about cumulative or potential cumulative impact, we're looking at Paul's Hill 1, which is there, it doesn't affect them. Paul's Hill 2, which does. Repowering possibly, as we've heard from my own friend Mr. Trinick, and then across the valley, Clashgar and Office 3. So perhaps another 5 to 8 years of development activity. Now, this is a pretty difficult situation for a small business to find itself in. Mr. Bonzer is no doubt fit, but he's 61, so he's not young anymore. And what we will say in closing is that this is just a risk that's too difficult to take, too dangerous to take, because it might wipe them out. I hope that's an adequate summary. I don't want to make a speech, but I hope that's a clear understanding of the issues for my particular client.
I did want to ask also specifically about the construction period. Appreciate it's a far smaller period than the 35 years potentially of the life of the scheme, but I think it's really particularly clear in Ms. Mandel's statement about what she predicts would be the impacts on her ability to operate her business at all during the construction process, given what arguably is a fairly unique position of being holiday businesses on the access. Well, certainly Glenarder is actually unavoidable for construction traffic. It's perhaps slightly different to Corgas, not actually passed by, but very close to. I just wonder what the applicant thinks about the construction period effects. Yes, limited in time, but are they not likely to be unusually severe?
The construction period for this wind farm will be approximately 1 year. There will be periods of peak activity in terms of construction traffic movements past Glenarder, and there'll be periods where most of the activity is up on site and away from Glenarder. We're going to talk about condition 15, the traffic management, in that session. The applicants are very aware of the potential for disruption, and when we come to the condition session, we hope to put some flesh on bones in terms of, although we'll be offering a scheme in the normal way, but that can cover a variety of sins, and we recognise that. So in recognition of that, we will talk about some of the detail that might go into that scheme. We do not anticipate laying fears to rest. That will never happen. But one of the things we will be offering is a proper, effective liaison system during the construction process, such that Mrs. Mandel in particular of our business will have immediate contact with somebody on the ground right there controlling construction traffic, and be able to say, I have these movements, I do not want to be interrupted at certain times of day or whatever. And that will be given priority. I fully understand it's easy for me to sit here and make these promises to Mrs. Mandel, who is genuinely and rightly worried about the situation. So I want to round off by saying it's not as if this is a housing development or a port or airport development that goes on for a year. It is a year. It is a comparatively short construction process for a major infrastructure project. And the position will be managed as best we can. I don't want to promise no disruption. That would be ridiculous. There will be some. And we will talk to Mrs. Mandel about that. Let's talk about the detail in the condition session.
If I could just respond by saying, it's very easy to talk about it, but the operation, the actual day-to-day practicalities of how it's going to work is, I don't have a whole lot of faith in the process of the liaison. Just not because I don't believe it's not well meant, I just don't feel it's going to be practical, because in the case of coordinating visitors, I can't define when they want to go to a distillery or when they're arriving. I can't have people screaming at me on the phone that they can't get into my house because, I mean, right now we haven't talked, so I don't know how long, when you say a delivery, what's a delivery? Is it 1 truck? Is it 10 trucks? Is it going to take half an hour? Is it going to take 5 hours? That I don't know. But the liaison is great, but if it's just going to be a case of you're going to phone me and say, okay, next week we have a delivery, and I say, oh, what am I supposed to say? Like, well, I have people in, they've got 2 kids, and they've got a whole week of activities that do I have to coordinate every day with them to allow, because people are just not going to accept that. And my other fear, and I know we'll talk about it in conditions, is kind of the emergency situations. If I have someone in who has a heart attack and there's a truck there and we're talking minutes to save their life, I'm not saying that can't be fixed, but I would like to know how we can address that, because I feel I will have like legal liability in that situation. If something happens to someone while they're at my place and they can't get in or out for a health issue or a fire or something, then I don't know if that would fall on me or them, but I've got a feeling it would come to me first. So it's kind of those issues.
I probably understand all you're saying. I mean, traffic management systems for construction programs are used to dealing with this sort of issue. They're not easy to deal with. They can be addressed. I don't expect you to accept that assurance from me.
It's just I personally don't have the time to deal with this every day to like start coordinating people's ins
What we
and outs.
can't promise is that there won't be from noise for construction traffic. We can't promise that your visitors won't see the construction traffic going past the door. What I think we can promise is that every effort will be made to avoid obstruction to your visitors coming to and from your business. That's all I
understand that. And
that's all I can
that.
say.
I just think that every effort will mean very little in the reality of the day of it happening, because priority is going to be given to your I mean, when you have a convoy coming in, you've got money invested in that. You've got a schedule to keep. I'm going to be the least down on the pecking order for my priority. I mean, that we're not even getting into the whole the other side of the position of my client's experience. I mean, once they do make it through, then they've got to sit and look at construction, and then we've got to listen to it. And I know we're going to get into conditions, so I won't even go into all of that right now further.
The only thing I can say is you will not be down the list of priorities. It'll be a high priority to maintain traffic flow for the purposes of your house and your business. Again, I can make this statement. I don't expect you to accept it, but it is meant. The situation is obviously more personal for you and more immediate, but this is not a new situation for many thousands of construction operations up and down the United Kingdom, residents are affected to a greater or lesser degree by construction activity. You can't hold all construction. And they are affected a great deal at some times with deliveries to and from construction sites. And many thousands of people are affected if you're in a large conurbation. So this is not new. I'm sorry to hear what you say about Paul's Hill 1, and we will do our best to do better on Paul's Hill 2 if it gets consent. I think beyond that point, we maybe go around in circles a bit, because I've offered you what assurances I can at this stage. I don't expect you to accept them, but I'm not sure I can say any more at the moment. Just one point to add about the road geography there. At least when you go there, sir, I went there again yesterday afternoon just to check the position before today, that it is a reasonably straight road with subject to weather, good visibility for over a long distance, and therefore control by a banksman is a lot easier than it would be if you've got a winding lane and you can't see around the corner. That does help. That the road geography assists.
I do want to give Mr. Bell a chance to tell us about some good things that could happen in socio-economic terms, but yes, Mr. Trini.
To make on influences on holiday businesses, which I think needs to be said, that there are very many influences on where people go for their holidays, where they spend their leisure time. Exchange rates, the economy, weather. There are numerous other things that influence people's decisions as to what to do. Trying to isolate one cause and say, if you do this, that will happen, I don't think it works like that. It may be that in some cases a wind farm or a housing development or some other kind of development will have an adverse effect on the business. I can't say it won't. But prospective evidence is extraordinarily difficult. What we've been waiting for 25 years is evidence of actual impact on businesses. I have yet to see any such evidence emerge at a public inquiry or in any planning application at all. I'm not saying such evidence is easy to bring forward, but you would think that if there have been such impacts over 25 years, we would have heard something in inquiries about it. We haven't. And therefore, I think that what you're left with is inventing a surrogate for the issue. And I think the surrogate for the issue is ultimately the landscape and visual effects. If you determine that the landscape and visual effects of this development on these two properties, the closest, the most affected, we acknowledge that, are acceptable, then I invite you to determine in turn that the impacts on the businesses will be acceptable. That's the only surrogate we have.
And possibly noise, but we don't want to talk about that now.
Sorry, if I could just respond about the reports issue, because it was mentioned before that there are no one has brought reports. I didn't bring some reports because they were from the US, so I didn't think they would be accepted. But perhaps there's no reports because nobody's done any. I mean, it's very, very hard to find any. So to find any to bring is near impossible. And what reports, I mean, I was given a report by your applicant regarding property value. Okay, that's slightly different than business, but it still all flows in. And that report itself said it couldn't measure properties close to wind farms because there weren't enough statistics. So I can't remember the name of the report that yourself mentioned before. They tend to be generalized, and they tend to be in a 10-kilometre radius, and they tend to take averages, or certainly the reports you gave me did. But there was no representation of the extremes. So you had this average, if from 2 to 10 kilometres, the average impact was this. But no one measured the impact on the most directly extreme of that, which was the 2 kilometres. And the report itself says it can't be measured because statistically there's not enough numbers on properties close to wind farms. So that's just in defence of not having the reports that you're saying we don't have.
Can I perhaps take issue with Mr. Trinnick on a question of a surrogate? It's quite an easy approach to say, well, if the landscape and visual impact is acceptable or non-acceptable, that should persuade the result. Mr. Bell has told us today that to some extent his conclusions are dependent on Brian Denny's conclusions. But I wonder if a way forward on this might not be this. You have the opportunity, because the evidence before you is of quite a full quality, at least on this side of the room, to make an assessment, an informed planner's assessment of the relative fragility of these businesses. Now, what Mrs. Mandel and the Bonses have told you is that they're fairly fully employed in the 2 small businesses. That's to say, not every day, but for a sizable proportion of the time. What I think you might want to ask yourself when you come to making a decision is, well, will the development increase that fragility, or will it harden it so that, or will it harden it, it's not very well put, will it reinforce the business, the strength of the business by being there? And if you conclude that it is a somewhat fragile environment, then you might also conclude that a development which is inimical to the reasons which surround the business, that's to say the landscape and the quiet and so on, you might think, well, this is going to enhance, it's going to increase the fragility and the precariousness of the business. And that ought to be enough to tip you away from granting consent. I just suggest that as an alternative approach. I think it's too easy to say landscape and visual impact equals possible tourism impact, because it's not the only reason, as Mr. Trinnick said, it's not the only reason people come.
Before I ask Mr. Bell to tell us some good news or predictions of positive effects, anything on the negative side that we haven't yet brought out? I'll give you a few seconds to converse.
If I could just address property value separate from business, pretend we didn't have a business and we were just purely doing property. And I know this is a very, you shouldn't ask or talk about it because no one is experts, but it's not included in any of the assessments at all, but it's just totally illogical to say there will be no impact.
Well, there's a reason for right or wrong. The convention is that property values, that direct effect, is not something that I or ministers should take into account. Indirectly, yes, if something were to harm your amenity in some way, and that was the result, that was the cause of the property value effect, then indirectly, I suppose we are. But we're not.
If our immunity is harmed, isn't that direct? How can that be separated from our property value?
Well, it is.
Okay,
Rightly or wrongly.
I know you're saying it is, but I totally don't understand how. I mean, it's when you take the business impact and then you layer on the possible property devaluation impact, which, I mean, you can read studies that say it doesn't happen, you can read studies that say it does happen, but it's asking us to take a financial burden of risk and a chance. And as is being said, renewables are going to get bigger, large turbines are going to get bigger. So it hasn't been tested, so there isn't a lot of information out there. But if I lose 25% of my business, and it could be, some reports would say 40%, then you're talking, I'm losing 50, 60, 70,000 pounds. That's a big part of my family's investment and nest egg for the future. So we've got we've got the impact on our business and the impact on our property. And then if you want to take in personal, it's a lot of impacts, and it's a big burden for a, dare I say, profit-based company to put upon a person in the public and ask us just to carry it and basically be a test case that if what is going to happen with 700-foot turbines.
Did you want to say anything in response, Mr. Trent?
Well, thanks. It's a difficult subject. I think I can only answer it by saying there is a reason for property values not being material to planning control, and that's based on the public interest in allowing development to proceed at all. Because if you go to any, say, take example of a housing scheme, the extension of that housing scheme will probably have an adverse effect on the values of the houses already there, and so life goes on. You simply cannot take account of housing values for their own sake in the planning process. What you can do is to say, look, if I have such and such an impact, and that in turn has an effect on property values, then that may become material, but it's the impact which is material, not the knock-on effect on property values. And that's the way the planning system works, rightly or wrongly.
Any other adverse consequences we need to think about, talk about? Okay, Mr. Bell, positive effects that you predict would or could arise?
Thank you. The EIA report looks at the employment generation effects that would arise, and this is on page 13.7, if you have that, but it looks at the number of job years that would be created in the construction phase, 72 in Scotland, 24 in Murray, and also in terms of operational employment, 4 in Scotland and 2 in Murray, and that would complement the existing employment that is in place. So that is that aspect. In my hearing statement, I also set out the further benefits in terms of referencing supply chain, but also the benefits, for example, that would flow through to the Ballindellic estate and the various activities that it progresses. And there is the Community Benefit Fund as well. And the Habitat Management Plan is another benefit, albeit not economic. The benefits are summarised at section 4.5 of the hearing statement.
The community benefit. It's page 4 of the hearing statement. I pulled out one of it to highlight it from there. I took from paragraph 3, 4.42. Yes, where Ballindellic is saying they recognise the benefits of Paul's Hill Wind Farm brings to the local Speyside community with the Community Benefit Fund payments. We had a look at what those benefit payments appeared to be over the lifetime of Paul's Hill 1, and that it over 15 years, and that looked to us to be 0.4 of a million, so 400,000 in the locality, which hardly seems to be generous. Especially in relation to the wind farm earnings.
The CD 12.1 is the summary of Paul's Hill, Rothes 1 and 2 benefits produced by the applicant, CD 12.1. The combined figure of Paul's Hill and Rothes 1 and 2 so far, in terms of community benefits, is 1.25 million. The Paul's Hill generation is £700,000. The new benefit proposed is in line with the Scottish Government expectations of £5,000 per megawatt. I'm not saying that's a material matter to be reported, but it is what is proposed in line with Scottish Government guidance on that topic.
Sir, can I just say that I have noticed in recent Section 36 decision letters ministers quite clearly distancing themselves from community benefit as a material consideration influencing their decision. I think that it's probably best not weighed in the balance as we do with planning appeals and inquiries, sir.
I've set Mr. Kelly's mind at rest. It's not material.
Anything else on socio-economic benefits before we go on to talk about conditions, or disbenefits indeed, if no one's thought of any more? My agenda's kind of gone out the window as they usually do. As I suspected it might, we've kind of strayed into, well, we haven't explicitly said what the net effect would be, because I'm not sure we'll get agreement on that, but because that depends on how if you do it purely financially, or if you apply a different approach, as Mr. Campbell was asking me to take in terms of the effect on the fragility of this particular businesses. So I understand you're not saying that is the sum total of the planning balance. You're just saying I have to take that into account.
I was just going to add that in terms of some of the topics on the agenda, we're looking at the evidence of positive or negative effects, but the assessment of the positive effect, the construction effect and so on, has been based on the foundation of the knowledge of the Pulse Hill 1 figures, as well as the Renewable UK and DEC report on job creation from renewables. So in terms of the strength of assumptions that have gone into those figures, they are strong, and in our view it's net additional effects. Appreciate the views that have been expressed from the other side, but there would not be displacement of other economic activity because of the development in a broad sense. So it can be treated as net additional positive economic effect.
I think we've kind of covered the final point. Do we have sufficient data? Your answer is yes, certainly in respect of the positive effects, and in respect of the negative effects, as good as anyone has ever had, I suppose, or as good as we're likely to get in the absence of any studies looking at what has actually happened, of which there seem to be few, if any.
Like the Limekiln decision, the Hester decision in Orkney, it's heavily dependent on tourism, and I acted on both of these cases, and especially with the Orkney one, again the finding not likely to be in effect, even though it was in the heart of the tourist area.
Can we move on to conditions? Mr. Kelly? Sure, yes, yeah, we'll have a short break. Mr. Kelly?
Can I just say thank you, sir? I'll be leaving at this point, so thank you.
Thank you, as always. Where are we? 22. Can we come back at 10:02? Thank you. First off, I'm very pleased to see how much work has already clearly gone into it, or them, and quite impressive level of agreement, it would appear. Always a relief for not having to go through it word by word for every single condition. What has worked in the past has been, I think, just to alight upon those where there is disagreement and go from there. Mr. Kelly's not here. I know, obviously, he's left because I was slightly concerned he might have. I know he was planning not to get involved until later on, but he's now not getting involved at all. So, I don't know, Mr. Campbell, have you had an input into this process today yet?
No, I haven't. I've read them, of course, but I'm not to say. I'm quite diffident on the part of third parties about interfering with the language of conditions because it's really a matter for the planning authority, unless it affects the client's interest directly. So I'm listening, but I'm not doing any editing.
Ms. Mandela, have you had a chance to read the list of conditions? Yeah, and I'm assuming you may want to have some input into items that affect you. I've not heard anything that would change my mind as to the best way, which is simply to, where there's agreement between the council and the applicant, we just ignore those and I can look at them at my leisure, bearing in mind the points that various parties have made, which I will bear in mind, but which means we can skip 1, 2, 3, 4, 5, 6, 7, I think. There's a few tweaks to 7, but
need to note, though, that the way we've treated turbine 1 in the middle column.
As long as there's clarity on which turbine has been removed, and yeah, thank you.
Condition 8, I think we're all happy with. Condition 9, microsighting. Again, we're happy, subject to what happens with turbine 1. 10, that's the cow.
I know there was a slightly suggested tweak to the start of the condition in the first paragraph. Our only concern is, and it's partly because we're in the section 6 process, we're slightly divorced from our usual consultees that we sit with for the planning application process. And then the suggested amendment, rather than a terms of the appointment be put to ourselves, consultation with SEPA and SNH, the wording suggested actually divorces that slightly, whereby the terms are opposed to the condition. We'd rather have it, albeit the terms that are suggested could come forward, but we would rather have it that, given the fact that once it was consented, we'd be doing this by ourselves, we'd rather have input from SEPA and SNH, particularly for SNH, into that process.
I don't suppose you're prevented from having that. You could, before you get involved, seek their assistance. I'm as guilty as anyone of chopping out any reference to other parties, although that's usually in the context of a planning application where I think it's up to the planning authority, and then whatever it chooses to do before it gives its consent is up to it. I don't know if that's why, if that was the motivation behind deleting reference to SNH and SEPA, is it's just not necessary.
General sort of best practice and wording conditions. Also, if you say in consultation with these people, what about other people you might want to consult? You might say you can't because the condition says so you should consult. So it's best left blank, frankly. You can consult who you want.
In the spirit of the absence of SNH at this inquiry, and with the ever-shrinking remit, my concern is, to be quite honest with you, is that if SNH are obligated to take part in that process, then they just say, listen, we're not taking part, we're not going to comment. So we'd rather have them obligated to assist?
Have any problem with? Yeah. I always chop it out, but perhaps that's the reason why councils put it in, and I never actually ask them. I just chop it out.
So we're feeling increasingly lonely nowadays.
I think it's 11. 11, habitat management plan. Yeah, I should have asked what was happening. There was the FOI request of SNH. I'm not sure where any of that has gone. We have the position of SNH, which is... thank you.
I got about 1,300 pages from SNH, which probably serves me right for asking them. Actually, it's really interesting, if you like that sort of thing. But they're not relevant to... it took a little while to get them out of them, but they tried very hard to be comprehensive and made close friends with the Freedom of Information Officer. However, there's nothing I could bring to the inquiry which would assist the issues that you have to determine. So I don't need to say any more, I don't think. I've got a good record of all the meetings of the Habitat Management Committee since the dawn of time. But perhaps I'll learn the next time.
Okay, thank you. That was helpful. I was conscious I'd forgotten to ask that earlier. So, no, thank you. That being the case, do we agree we're not going to get any revised position from SNH, and that unless I unilaterally think something needs changing, in which case I would have to come back to the parties for their views. Subject to that not happening, condition as worded is satisfactory. Are you happy with that? Thank you. Redundant turbines. There's a question about the timing, or how long you get before you have to remove it. Is this right? 12 months or 6 months?
Just in terms of ourselves, I noticed there's other examples and model conditions where 12 months is offered. The only thing that, and again, this is not so much about disagreement, but just obviously these last amendments are fairly new. And the condition, there seems to be a kind of trigger where, and if I'm reading correctly, if in the 12 months a turbine fails to operate, let's say, then a scheme for its repair and restoration comes to us, which, if I'm reading it correctly, seems to buy a lot of time or puts the onus on the council to some of them consider that and respond very timorously if it's commercially not operating. Whilst I think the ECEU model condition just has the proviso if it hasn't worked within 12 months, then it has to be tell us how we can remove it. I just worry that basically after 12 months, time is bought by putting something to us to consider its infrastructure and restoration. So if it's what's the phrase? Sorry. Yeah, it's basically it's repair. Then that's the worry that we might be. Yeah, it's repair and replacement. Then that's bang a lot of time while it's not working, and it makes obviously instantly puts a lot of pressure on us to try and respond to that timorously and quickly. For example, things like in terms of a scheme for its repair or replacement, one of the things I was thinking off my head, we'd have to go and check that since the normal roads was done first time, that we put new bridge in somewhere en route, things like that. So it worries me a bit that it would be potentially more onerous than maybe all parties might think if we were to allow that. Other than the model condition of the ECDU has it that after 12 months it can be removed. But that extra proviso for repair or replacement just to me seems quite loose.
As it reads, we're saying that unless at that date of 12 months, we have already submitted a scheme for repair or replacement to the Planning Authority for written approval, then we will submit a decommissioning plan for approval. So I don't think we're buying more time at all. And it too says, well, if the company has not submitted a scheme for repair or approval at that date, 12 months, which is defined to be the relevant date in paragraph 1, then we have to submit a decommissioning and restoration scheme anyway. So there's no time being brought there, but I think it's, first of all, 12 months is fair because it can, supposing there was a particular part that took a long time to get. I hope that's not the case, but if it was, it could take more than 6 months. Secondly, that it's in no one's interest to take down a turbine that can be repaired and made to work in a reasonable time. I think it's perfectly fair. It's a decent balance.
Presumably the scheme for its repair, in the event, I don't know, that the tower fell over or something, that scheme would incorporate within it how you would get the tower to the site, presumably, which would address your point about somebody's built a little bridge in the way or something.
Yes, I think also it covers the eventuality that the planning authority might say, oh, you're taking out the whole thing and replacing it, needs new planning permission. So it covers that. The submission of a scheme allows you to make what comment you want.
Yeah, let's see, I'm reading the first of yesterday, so okay, I take your point. The only other thing I'd maybe suggest there is that, or raise, is there any elements of that placement that would have an impact on conditions that are deemed, that are part of the other conditions of the consent? Maybe not, I'm just thinking, I'm trying not to get us all caught out down the line. But
well,
yeah,
I think you have to look at the position afresh when you get the scheme, because the construction conditions will be spent. You can't re-invoke those. So you know, when you get the scheme, you look at it and say what you want to say.
Okay. Yeah, just to understand the flow of the condition, in the event that there is a replacement required, how does that flow time-wise, and that we're not getting accused of. My concern, partly, as well, is that if we take a time to look at that replacement or restoration, for whatever reason, shrinking manpower, that we might be getting accused of costing you money. I was not spinning anyway.
All we're waiting for is to be able to, well, it is costing money, but what I mean is, if it's possible to get on and repair the thing anyway, we're going to get on and repair it. Not going to hang around. It costs money, as you say.
Thank you. Construction environmental management plan, always complicated. Yeah, are you in agreement? Sorry, this one I haven't read the notes of.
Discussing what we were trying to do is, we were suggesting that we made, I think the 30th of September, I think that we read for the first column. What we were just trying to do was, our transportation obviously want to have an influence in construction, which discussion we had with the applicants earlier was a genuine work together trying to filter out. Obviously, between Northwest 1 and 2 and Paulsville 1, there's obviously continual traffic there in the sense of personnel, some vehicles, some larger vehicles potentially, which will legitimately occur between those different locations. And we're trying to work a way of filtering out filter that out from the construction traffic for Paulsville 2. Oh, 13, sorry, apologies, I jumped to 15, enthusiasm, sorry. Yes, sorry, construction, condition 13, yes, that small change of condition 13, sorry. happy with the changes to condition 13 in yellow as well. Sorry.
Yeah, 14 archaeology. It's a question of how much detail you need to go into, I think, given what the applicant says is the lack of any obvious interest, archaeological interest in the site. So you use Aberdeenshire's, archaeological service, and you're proposing the condition that they like. And the applicant's view is it's excessive.
At this stage, the condition is unnecessary. The WSI can define itself in terms of what the local authority want. But to specify details of recovery and recording and post-excavation analysis in the condition is just unnecessary, I think.
Our position is it just gives, it's no more onerous, but it gives greater clarity, and certainly that's our archaeology colleagues from Aberdeenshire who cover ourselves, Aberdeen City and Aberdeenshire, find that wording effective and implemented.
It gives a hints to what might be required, but ultimately you could say the WSI isn't adequate, or it doesn't. I appreciate why you want to set it out up front that these things might well be required, but I guess, I'll have a think about it. I guess the question is it necessary? Because I'm sure they'll employ competent archaeologists who ought to know the sort of things that are likely to be required. And if it isn't, then you'll say, sorry, that's not good enough. I'll have a think as to which, if it's necessary or not. Now, traffic management plan. Oh, crikey. Help.
Potentially, but sure, we're looking at the only thing between us is paragraph B on the second page of the condition. It's about it's about routing, and I think what's been agreed this afternoon is if you take out the coloured wording, so it ends including monitoring procedures full stop, that then leaves all routing to paragraph A, which indeed provides for the improvement of routing. So I think that, because we weren't, I think, going to reach very precise agreement on some things this afternoon, we don't need to debate it, so let's revert to the ECU approved condition. I think that's right, Neil, isn't it?
Yes, the only thing I think is that my transportation colleague was sitting next to me giving me a kick under the table. I think we'd like to have that routing element of specifying the comments that are attached are maybe inappropriately contained within condition B, because they always want to have that from the outset made clear. But I think, the problem with that, and as we've accepted from the discussions earlier with the applicant, is we need to filter out a way of separating the operational HGV and other traffic from existing windfarm and Rothus 1 and 2 from our construction traffic. Whether we revert to the ECU draft, we want to be careful. I think an applicant is the same. We want to be careful that in that traffic management plan we filter out, whether we filter out the existing traffic. I know that transportation colleagues are going to be keen to make clear in the condition just now about the, let's just call it the construction-related heavy traffic travelling south out of the site towards Mary Park rather than going north via Archestown or north via Dallas. But they would probably want to have that element retained in some shape or form. I'd suggested in the discussions maybe somebody tailoring that into the Part E as a subsect of Part A, or that's something that the routing should contain. But whether you want to do that yourself or sorry, we'd be anxious about moving it all together. So.
Clearly there's a requirement to go through this in terms of that specific area. What is it that's now being proposed? My understanding is that the coloured wording comes out, we still have B in terms of the ECU standard, takes us back to A, but that then allows us the full process to agree those routing details and differentiations.
I think what we're doing, trying to be upfront, especially in the future, if the condition was challenged or whatever, we want to be upfront that key to the routing of the development, traffic associated with development, is that there's particular routes you want to have made clear are not to be utilised by heavy construction traffic or abnormal loads. And I think that's just trying to make the condition more precise from the outset. Sort of think the Treasury discussed about we don't want to cause another headache for anybody complaining about other existing construction or operational traffic. That can maybe be fleshed out in the overall TNP. But then you just want to have up front the north to the site should be made clear that they have to be avoided by the heavy construction traffic.
Short of a long debate, I think it's best to leave A as it is, cut out the wording in colour on B, and leave the matter to be debated more precisely at a later stage in the light of circumstances as they are then. We're not happy to agree the specific coloured wording in B as it is. So we'll have that debate later.
So our position would be, obviously, this maybe just comes down to A. We would want to have a more clarity in the condition about the main routes you want to avoid it.
I don't think we'd argue over the
What wording do you suggest then in A?
This is a draft I'd written today. Was that under A, the details of the routing of all the construction, HGV and normal road traffic associated with the development of the local or trunk road networks must access and exit the site in the B910 to A95 Lady Park Junction only. I'd hope that is informing the overall TNP. Does say the TNP must include, it can cover other things. So that would then make sure that the heavy construction traffic and the road would be bound to access north and south via the A95 to the south. But then that, hopefully, my thought was that wouldn't then constrain all the other operational traffic that goes back and forth, Blockers 1 and 2 to the site, or even indeed smaller construction traffic like vans and cars. But again, that happens to be have other reservations. But from our perspective, that would then filter out positively the traffic we wanted to head south from everything else. Again, I was still getting kicked by my transportation colleague under the table. I thought that would then give, in terms of putting an enforcement hat on, we wouldn't be stopping anything travelling north other than heavy construction, HGVs and along the roads.
Would we then also need to have in the condition a definition of what is a heavy goods vehicle or heavy construction? Maybe the downside of having the clarity in the condition is then the condition has to have lots of definitions, and whereas if it were set in the plan to which you would have to agree, all of that could be set out in there. I can see both arguments. I know you want to see it clear on its face, especially if there is no way you're going to agree to anything else. You might be saying, well, why not put it on there? Because we ain't going to say yes to anything other than that. But I can also see
this condition gets the main principles down in place, TMP.
Which will be resolved by the TMP, where you go into greater detail. What is a heavy vehicle in that regard? You can work through detail. I'm not sure I see the need to go beyond the standard condition from that point of view.
I suppose arguably it might make your local residents better able, as acting as your eyes and ears, if they can just look on the decision and say, hang on, they're going the wrong way, or, rather than having to refer to another document that might give them, although I know people are pretty good at referring to other documents and keeping you on your toes, but I'd just have to think about it. I understand both of your arguments. 16 construction hours, I think, are pretty much agreed.
The only thing there on the hours is there's in the yellow draft there's reference to rather than us being informed of out of hours working, let's just call it, the certain operation just be carried out without those hours, or 2 days notice for other works. Our experience is that basically the way the word was conditioned, we would never stop reasonable in terms of certain types of works occurring, concrete pouring, etc. But we find it very useful to be informed of that, because we ourselves or Environmental Health Department or other people get complaints about somebody working under floodlights at midnight. If we know in advance that's it's concrete pouring, they've got a spell without wind, the cranes operating, and we know about it in advance. We find it very useful. It means we can instantly to other residents and other people tell them that yes, we're aware of that happening, and it's permitted. So it's not that we want to curtail them, it's just that as an authority that receives complaints from individuals about out of hours working, let's call it, there are concrete pourers or turbine erection operations going on. Having us informed of it is very useful to us.
The difficulty is that these things happen by their nature unexpectedly. If you start concrete pouring and for some reason it's not finished within the construction hours, you simply have to carry on until it's finished. And it's not a question of writing to the local authority and saying, we suddenly realise this has happened. It can't happen that way. Also, for turbine erection, if you get unexpectedly windy conditions and you've got the crane up there at the end of the day and then it drops, you want to carry on. And for emergency works, well, I'm not sure I can notify you of an emergency work. So it doesn't work that way. It has to be post-event notification. It's the only way it can work.
I could suggest what we have done elsewhere, taking in board your point, is that the way the condition is worded is that certain operations can just occur, as you've suggested there. We have I think it's actually in the Callan warehouses where the condition says something like, in the event the works have to occur with these periods, such as the ones that define concrete pouring, the council is notified at that time. That just means that we at least have an email saying, listen, the wind's dropped, the wind's gone up, you can carry on. And then it goes back to that point, we know why and what's happening. So that might be that, obviously there may be some operations, as the Commissioner suggests, that you get 2 days, 2 hours of notice, but if some operations, at least we're notified of it, then we know about it. And that's really the point. It's not so much that we want to constrain. We understand that out of hours working has to occur for construction purposes. We're just being notified of it tenuously. Like a site, like we, just now, for example, the site mentioned the site manager will email me and the environmental officer saying, sorry, course had to go on. So So at least we know then that it's going on, and that means that we get contacted. At least somebody has an understanding of what's occurring.
Be careful what you wish for, because if we notify you, then you know. And if you're not there, and then someone says later, well, you were notified, why didn't you do something about it? I'm not sure. Be careful what you wish for. I think you're a bit safer under the system we put forward. You know?
Could I just ask a quick question about the out-of-hours deliveries? Because I see that that is allowed for turbine deliveries components. So I'm just wondering what I should be prepared for. Is that a normal? Is it going to, like, how much night time is typical? Is it, yeah, is it likely that it will be often at night, though? Is that a possibility or something that's normal? Exactly. That's why I'm asking. Yeah, because I'm just concerned about guests and noise and nighttime lights. Because the other night a truck went down and I was in bed and boom, the lights, they came on, and it's very disturbing. I'm just concerned if I already have people in, there's nothing I can do about it. Mm-hmm.
Okay, shadow flicker 17. You're in agreement with, I think, applicant. And similarly 18, I think everyone's happy. Private water. 19 is agreed. 20.
20 is one where I think applicants have been kind of suggested the Ministry of Defence have said you could have either aviation lighting or infrared. I'm going to remember this particular committee last year, but certainly our members have standing of a preference, if we're possible, to minimise impact for nighttime. If there's choice, they ask for us to pursue conditions for infrared lighting, if possible.
So we're all happy. decommissioning methods statement agreed. As is the bond, I think. Yeah. Ignore noise for now. So that's 23, 24. Look forward to those in November. 25 access. Right, this is a Land Reform Scotland type thing as opposed to people shooting.
I know it wasn't, so it was, there's, and I'm mindful we were involved in the socio-economic side of things, but again, it's one of the things where normally for we would be asking for an access plan. I note the applicant's comments that this is a hunting estate. Really just putting it out there that really, to our mind, we've got a fairly distinct access and a route up Roy's Hill, a track all the way to the top. I know it starts the wrong side of the rock cut, which, as the Mary Warren-Milcom was saying, that we feel that there's an opportunity to have some kind of access plan, in a sense, would be assisting the wind farm and the state to keep people onto that track and up to the summit and down again. Not that they'll still have the rights of access, but normally it's normally something we'd be asking for any wind farm an access plan in some shape or form to clarify access, if not to enhance it or diminish it.
I'm no expert on Land Reform Scotland Act. I have done a core path plan once, so I should know a bit more about it. I'm aware there are provisions at times when people are shooting, not that you particularly want to exercise your rights at that sort of time anyway, but my understanding is I'd be quite entitled to come and wander, other than at times when the estate is shooting, I'd be quite entitled to come and wander as I saw fit. In that case, well, that works both ways. Do we need a plan, or what's the harm in a plan? If, in a way, the council's point is, well, the plan might actually just organise things. I appreciate you don't want necessarily people wandering up and down the main access track with its rocky size, albeit they are protected by the mesh and stuff. I presume that's why the signs are there, is just to effectively just to warn people that you do so at your own risk. Yeah, you're not actually really saying don't come in, it's just saying it's probably not a good idea. But is there really any harm with an access plan that might actually find a way of encouraging people not to go that way?
You're assisted to some extent by the provisions of the Act, because you can apply to the local authority for exclusion from freedom of responsible access, which is what it's called, not right to roam. And that can be whether it's a golf course or a shooting or a construction site or a dwelling house, for example. You can get those restrictions for a limited period, or if you're very lucky, indefinitely. So the process isn't difficult and it isn't expensive. But otherwise, Mr. Bull is quite right that the right about I won't say anything about the no pedestrian sign, it's clearly illegal, but the right of access is transparently there. Yeah, all right.
Sam. That's it? Is that really it? I don't believe it. Excellent.
I've got one other.
Yes, another condition?
Maybe part of a condition, maybe part of the works, the conditions covering the normal loads, etc. Obviously, it was part of our committee recommendation and endorsed members that one kind of tail or footnote was that we didn't want to see the existing rock cut be increased or in size at all. I don't think it's necessarily been suggested by the applicant, but we should rather have that as a condition of the consent or secured in some way. What's something specific it has, it's obviously it's a feature of the landscape. You don't want to see it freshened up or increased in size. I don't think that the applicants are necessarily saying they want need to go there or increase its size, but I think it's because it's something that our members then supported that we don't have it covered in some way. Maybe the construction, the normal roads plan or the other roads, etc. will might cover that, but even if it's not for normal roads, you just want to make sure that rock cut doesn't unnecessarily get increased in size.
I'm surprised you weren't going further than that and saying, can't they do something to improve it? But
I was going to jump in with that final question. The regeneration plan for the cutting, because it's right now it's been existent like that for a long time.
Dealing with Neil's point that you've got control through the construction method statement. We can only carry out authorised works. Therefore, if something was to come forward that interfere with the rock cut, you could say no. And I just confirm there are no proposals to do anything to widen it or any excavation works at all. I don't think you need an additional condition for that. You can cover it through construction method statement. Answering Mr. Mandel's point, we've discussed this. There have been efforts through the years, through hydro-seeding and what have you, to try and get it. But the steepness of the rock makes, as you've seen, that very difficult indeed to achieve. And therefore, short of what you really don't want to happen, which is widening it and stepping it and doing all sorts of things to make it look worse, frankly. It's not a pretty sight. I agree with you. There's a Paul's Hill 1 thing, not Paul's Hill 2, but it's trying to think of something to do to make it better without making it worse is actually very difficult, and that's the issue, I'm afraid. So we're not proposing anything to improve it. They've tried and failed, frankly. Sorry.
okay, no other conditions, anything that we need to talk about? No, excellent. Okay, well, I'll close this session and adjourn the inquiry until, I think we have a date of the 19th November to come back. I don't know, Ms. Mandel, how your travel plans are. Right. We have been looking at venues. I don't yet know if we have an answer as to no. No. Does that mean no, we don't know, or no, we're not getting? We don't have an answer. What we were looking at the possibility of coming back here, and one of the considerations might have been, which we talked about at the pre-examination meeting, and where the possibility, if you weren't over this side of it, and you could do it by Skype or something, which requires a reasonable Wi-Fi link. And although the Wi-Fi link hasn't been wonderful in terms of uploading a lot of the footage, Ewan has tested out by Skyping back to the office, and it does work to that extent, assuming that we had, because I think it's your Wi-Fi that we're benefiting from. So then that gives the other potential difficulty of timing and the time difference. I've done this with people in Australia, which is actually quite helpful. We can do it first thing in the morning and they're doing it in the evening, but it's not quite the same for you. Five hours, okay. Yeah, that's not there. That's not. What I didn't want was for you not to be able to see the start of it, so you just coming into it completely cold, not having heard what anyone else had said. But right, well, we'll think about that. As I say, we haven't got a venue sorted out as yet, but if everyone's happy with this venue, then that was an option.
There is a question, though, of determining when you want revised inquiry reports by. I'm not sure we have that date yet.
All right, there are some dates that Snera ran by me. I think the plan was 6 weeks prior to the 19th of November for documents, including inquiry reports, and 3 weeks prior for recognitions, whenever that is. So gives about a month. I mean, it's a month from now to do inquiry reports. I mean, if you tell me that's completely unreasonable, my brain's not working now. Unrealistic. That was the word I was thinking. There were excellent. And then the usual 3 weeks prior to the inquiry starting for recognitions.
About the core documents, because the noise stuff is kind of spread throughout. Will you be looking for us to retain them until November and bring them back in November? Or will it be possible to refine them down, or I don't know.
There's maybe some core documents that are definitely not noise.
There may be policy documents that we still need, and yeah, that's probably it. So yeah, it's not really for me. It's anything to which the parties intend to refer. So I guess you could have that discussion, and it could be core document bundle number 2, which will be much, much smaller, depending on what any of you want to refer to in those 2 days. Excellent. Thank you very much. See you in November.